Prosperous New Year to all of you.
End of the year, we can judge it. Because in 2020, somebody told me, Happy New Year, thereafter COVID came.
Always there will be a proviso.
My lord,
Yes.
but I think your lordship kindly to mention. This matter was due to appear today.
Due to appear today.
Yes, my lord. My lordship has ordered this.
Oh, sure. Yes, as per the court officer, somehow it has missed. It will appear on 9th, coming Friday. 9th of December. They can even.
Preferably, my lord.
As regards to upgradation, রেখে দিন নাম্বারটা রেখে দিন নাহলে second appeal.
Yes, Article 227. They will leave it.
Why are you saying second appeal? Dismissed by?
Dismissed by I have already served the notice to other side. 2006 matter.
No.
I have served to the notice to the other side.
Has the notice been served?
Yes, ma'am.
Where is the endorsement?
My lord, this is just service.
The service.
This is
What a saying.
they are from it. It will reveal that it has been received. So,
My lord, I have seen. My lord.
whether sending and received by the other side is same.
No.
So then, on the next day, you serve and come with the appropriate step as regards to service that it has been served on the next day, next Friday.
Kindly, my lord, allow me.
Next, Dakun.
Item number 1.
Whereas we have already argued both ways, some supplement is there.
Some additional,
3 judgments while Mr. Ghosal referred to. I said that I will answer to that.
those are to be
No,
First
judgments, but last occasion that was we have mentioned it. But earlier the judgments are also
They're
there.
all in their written submission.
additional
3.
3 or 4.
3.
Three.
Only for this matter I have to come today. It is good. Start with.
So fortunately,
Now I have to go to.
enjoying the company of Mr. Nas.
I have to go to Balloon Town. Justice Kollanjiti Sengupta's mother passed away. My lord has probably come. I have to go there. After this matter, I will go.
So, can we start now?
Yes, may please your lordship.
আগে ওই রিটেন নোটস গুলো দিন হ্যাঁ এনভেলপে আছে
This is ওই
সার্ভিস তো হয়নি। সার্ভিস হয়নি দেবে না। দেবে না। সার্ভিস করে আয় দিয়ে দেবো।
এখানে ছিল না বলার জন্য বক্সটা না ঠিক আছে।
So, on behalf of the appellant, AIR 1968 Calcutta 550, AIR 1975 Calcutta page 200,
Yes.
2012 volume 6 SCC page 430,
Yes.
and 2016 volume 6 SCC page 576. 576. 576.
That was the earlier occasion.
Earlier,
Last occasion, we have given 3. That we have given a copy to a friend.
Are those mentioned in the Written notes of argument.
But,
Are those mentioned in the written notes of argument?
yes, yes. These three are already mentioned, and which is not mentioned, I served it in last occasion. Last three. Well, the entire branch is here.
Altogether, no. Altogether, how many?
I
4 plus 3, 7.
total 9.
Total 9.
তো খাটাবে জজ সাহেবকে 9টা জাজমেন্ট দিয়েছো
On
So,
section 7.
including the earlier one, which minor I read out just now, and last occasion 3.
All on section 11.
No. On 11 and also other points.
Acha. So, acha.
And on the status of the caretaker.
Acha. So from the written notes of argument from page 7,
Yes.
it transpires that 4 or the 4 judgments have been cited. Apart from these 4,
3 we have given. Last occasion, we will copy to my friend.
to the court,
Yes.
where are those mentioned?
Well, the last occasion is handed over physically.
Supplementary.
Complete judge.
The last occasion we mentioned it, but it was not. It was after the compilation.
Okay.
That's why it is not seized.
আর কিছু written notes বা কিছু আছে?
It is
এটা কমপ্লিট করা আছে
ওনাদের-
আগেরগুলো আছে
ওনাদের
Subject to my lords, kindly, but we have prepared a second list, complete list to assist your lordship. If my lord so considers,
খাম আছে না খামের মধ্যে ছিল
That-
একটা খাম দেখুন তো আছে ওর মধ্যে ছিল
ঠিক আছে? ঠিক আছে। তো এখানেও নেই। So that is supplementary written notes of argument.
আবার
this is the complete list, including the earlier original supplementary list and the last addition of the last occasion. Both are come together. It is complete one.
only citation.
এটা দিয়ে দিন, ওটা দিয়ে দিন।
আচ্ছা,
পুরো
দ্বিতীয় না,
record,
confusion,
পুরো
পুরো
record,
confusion হয়ে যাবে।
পুরো রেকর্ড, এইটা পুরো রেকর্ডটা দিন, রেকর্ডটা দিন।
রিটেন অফ আর্গুমেন্ট ওর সাথে 4টি দেয়া ছিল
হুম।
এবার সেগুলো আছে আর
With this written notes of argument, 4 judgments were included. And subsequently, another 3 has been included. That is in the supplementary that was not handed over.
ও, দিয়ে দিন, দিয়ে দিন, দিয়ে দিন ওনার।
This is all right. This is the first one. Subsequently,
Till
the
now-
last occasion we added 3.
Till
That is in this the entire band. These
now-
both are here.
Till now the court has this one. ওইটা কোথায়?
This one court has this one.
Only the one which is on the top.
Yes.
That is the written notes of this one. Apart from these things,
3 more
3 more, and that's why that this one and these 3 more are together in this bunch.
Acha. So this one is the supplementary.
Yes.
So we will now consider, the court will
don't
consider.
go by the supplementary other thing original written submission is there
Hmm.
only 3 added that may be separately handed over
So this one won't be considered, only this one will be considered. Which is in your left hand.
Notes is also there.
Acha. In that one, only the citations are there,
Yes.
not the written notes of argument. Acha.
hand over separately no
Acha.
problem.
Written notes of argument is here,
ঠিক আছে,
and all the citations are there. So,
Nothing new.
Mr. Basu, you have received all. So altogether, how many judgments? 7 na 9?
ওটাতে কটা আছে
টোটাল নাই
অরিজিনালটা
অরিজিনাল
3 additional
Let it be first. Let it be first settled.
3 additional I am ready with that because
No.
they have filed a written submission we have filed all
Altogether, how many? 4 plus 3.
Total,
plus 3.
including supplementary 3 is 9.
কি করে 4টে আর 3টেতে হয়
That is to be first settled.
তোমার written
Mr.
submission
Ghosh,
দেখো না।
Mr. Basu,
ওখানে
না,
দেখতে হবে।
এটা
sir.
মিলিয়ে দাও
সার্ভেন্ট যেটা আছে 3টে
মিলিয়ে দাও ভাই, মিলিয়ে দাও।
তার সাথে টোটাল এটা কমপ্লিট করে দিই
না 7 আর 3 দুটো বেড়ে যাচ্ছে তো। এটা মিলিয়ে দাও, মিলিয়ে দাও ভাই একটু।
75 68 আর 2012 এইগুলো দেয়া ছিল
I find 4 here and 3
Uh,
additional.
Yes, 4
4
are
here
four
in
are
their
here.
written submission
Ah.
and 3 additional. It is here.
Hmm.
The Ghosal cannot develop this.
Hmm.
এই তো,
No. That is there is no doubt about it.
4টে আর 3টে
This was given originally, that is
Eight.
along with the notes.
These 4.
And subsequently 3 were given.
4 plus 3, 7.
So this-
9 কোথা থেকে জন্মাচ্ছে আবার?
ওটা দেখিয়ে দিও কোর্টকে।
That is the question. Where from 9 is coming? It will be 7.
মিলিয়ে দিয়ে
পরে যেগুলো আপনি দিলেন,
পরে দিলে স্যার দুটো বাড়ছে তো
সেটা আর্গুমেন্ট করো
সেটা তো-
এই তিনটে করে দাও, এখানে শেষ করে দাও। পাঁচগুলো তো আটকে রেখো না।
মাইলটকে দিতে হবে।
এগুলো তো এটাই আছে, আমরা কভার করে দিয়েছি। এবার ওই তিনটে আমি বলে দিচ্ছি।
রাজ্যের সাথে শুধু জাজমেন্ট সাইটেশন
শাস্ত্রীরা দুটো দুটো মিলছে না সেটা দেখে মিলিয়ে দাও একটু
That is to be first settled.
That's no problem. No.
Settle 3 additional and 4 in the written argument already filed. 7.
That the court has got it. But where from 9? That is the question. Whether 7 or 9?
না, এই চারটে মেলা।
আর যে তিনটে দিয়েছো
তিনটা,
সেই তিনটে
স্যার দুটো দিয়েছিলেন সেই নটা হয়েছে।
সেই যে তিনটে দিয়েছিলাম সেই তিনটে দিয়ে খালি লাগিয়ে দাও আগে লাগিয়ে দাও যে তিনটে আগের দিন দিয়েছিলাম এই চারটে এই ছটার সঙ্গে ওটা লাগিয়ে দাও আর কিছু দিতে হবে না
ওই চারটে আছে, তিনটে যেটা বলবে বলে দাও।
So, be seated.
Hmm.
Let it be settled between the learned
দেখে দে
learned counsels, learned advocate on record on behalf of both sides. Let it be first
বাদ
settled.
দিয়ে দাও
Written there.
ওটা করে দাও ওটা কোথায় জজ
First issue for the for this year should not. You are the advocate on record.
Yes, sir. Is the junior here.
Have
In
it.
fact, his long journey is there at intervals. If my memory
That won't be that won't be any
my
problem.
memory doesn't fail.
No, that won't be any problem.
Mr. Basu completed his submission by a reply.
Hmm.
Then the matter was, it was 130, no question of reply of reply. So that
As
was-
I have
because-
also give, you have added, that's why I have.
As because 3 additional judgments
That's why
have
I'm
been
here.
that's-
referred,
Thirdly,
that's why.
whatever if I say something new, he must have the right of audience.
That is.
That is no doubt.
Bhavya Singh. Bhavya Singh কি করতে এসেছে?
But before he's screening it out.
তুমি এই তিনটে বলে দাও না, ওয়েস্টিং আওয়ার টাইম।
So, হ্যাঁ
বলে দাও।
before I cite the judgments, the 3 judgments, because it is a long time, I have to link up these things just for 5 minutes. Your Honor knows, my Lord knows that the suit was decreed in by the trial first court, learned trial
Trial
judge.
court.
Appeal court reversed it on the only on the ground of res judicata. That is a fact.
Against which you have preferred the
Against this-
second appeal.
Now the question is, the 2 things are there. Before I come to this judgment portion, just I have to link up what is there. Because it is necessary unless I refresh the memory, because we are all human beings.
Hmm.
Just as I am refreshing the memory, I will be speaking 5 minutes.
Yes, yes.
আমি যদি রিফ্রেশ করি তখন কি?
করো ক্ষতি নেই, welcome. Welcome. So after all, it is appeal, not a suit. So I have something to assist the lordship to in my humble way. Now the question is, as I submitted, now kindly come to, so kindly excuse me, my lord. Kindly see the points formulated. I shall be confining to that only by
কি বলে?
last part 1 to 2 pages.
The
Our paper book.
order.
কিছু বলেছি আমি কি মুশকিল Has your lordship got it? Last part 2 pages. Justice Tandon and Justice Chaudhary's order.
1, 2, 3.
Yes. If my lord permits me to read about what the actual formulation is there. Whether the Court of Appeal below was justified in reversing the judgment and decree of the trial court solely on the ground of res judicata, without ascertaining whether in an earlier suit filed by the respondent defendant for injunction, there was any service of summons upon the appellant or they contested the said proceeding and suffered the degree. Now, these 3 ingredients are there. to ascertain whether the service of summons was there, or whether they contested the suit and they suffered the degree. That is the criteria to be given. So now, question is, answer is at page 32. Answer to this question is page 32. Paper book. Can you see? Only one principal defendant. And my client was number 2.
Hmm.
That was the
Anandamohan.
Anandamohan. There is nothing on record that there was service of summons or the file a written statement or the issue was framed on my written statement. Nothing is there. That would be available in the next subsequent pages. Can you see page 33 and 34? Very self-explanatory. And at page 33, paragraph 5, paragraph number 5, my title admitted. 4, 5, 6, and 4, then 8. And another very significant thing is there. That is come to page 35, paragraph 10, middle portion. Allegation against the defendant 1. No allegation against my client. Nothing on record that their service of summons was there, written statement was filed, issue framed, adjudication made, nothing of the sort. That is the only reason I am referring to this. Can you see the explanation? Why pro forma? What is the status of pro forma? My client. My client is pro forma. Page 35, paragraph number 12. Plaintiff requested the other owners, including my client. The ownership is admitted. Namely, the defendant 2 to 4 to join the such and such. They have not agreed. They have been deeply implemented as pro forma defendant. So that is the explanation given. What is the role played in that suit, in the original suit? Res judicata was with all my limitations and shallow knowledge of the law and the English. No, yes, you are a strong confidence is there. Can you see? Unless there is adjudication of the right, issue framed, pleading made, adjudication filed, adjudication made, I am not bound. Even if there is a degree there. Because now the very important thing is that the page 36 prayer portion. For degree of permanent injunction, restraining the defendant 1. No prayer against me. I am speaking of this because of the res judicata, question of res judicata. Unless there is adjudication of my rights, either directly or collaterally, the question of res judicata doesn't arise. That is why, and that is coming page 37. 1 to 12 are not true to my knowledge. Order 6 to 15 of the Code of Civil Procedure. What is knowledge, what is submission? So those facts have been stated to be admitted to be correct. So these are the matters on record. And upon this judgment, I have been affected by the appellate court's order. Because there is no, there cannot be res judicata unless there is already adjudication either directly or collaterally. No relief against me, no written statement, no issue frame, no adjudication made. So my humble submission would be, firstly, the prayer by appeal should be allowed. The alternative prayer would be it should go back on remand. What my landed friend was submitting last occasion. Yes. First prayer is the appeal is to be allowed because this is basically a wrong thing. And even if not, at least it should go back on remand. Because it is a non-application of the judicial mind that is substantial question of law. Non-application of judicial mind is substantial question of law. These are on record. In spite of that, I cannot be held up for res judicata.
So this is the sum and substance.
That is a basic thing. I shall not go beyond what is already there. No, just kindly come to my lord. I certainly will consider it. Page 38, judgment. The source of title is as claimed by my friend's client, as we explained, which includes they admitted me to be a co-sharer. They have filed a suit for partition against me, including myself and other co-sharers. Moment you file a suit for partition against me, you admit me to be a co-owner. Partition presupposes antecedent title. Fraction of share may be disputed. But the fact is that my friend's clients had admitted me to be the co-sharer. So if that be so, if you have a better title than the occupant, then I am entitled to get a decree under Order 7 Rule 7 even. 1975 Supreme Court, Calcutta, page 200. Judgment of Justice R. Bhattacharya. If I can prove a better title, if the relationship fails, even on the question of better title, I shall get the degree. That part has not been considered.
That thing is reopened now.
No, you can answer it, certainly.
No.
That's why I am telling you.
Mr. Bhushan, let not
But-
blossom.
No, I said, no. I shall simply point out what is what. What is what. Where my lord will get the relevant questions. That is why I'm not reading out.
These 2 points will give the entire scenario.
Yes, that's why I'm simply giving the pages. Wherefore the issue decided by the landed appellate court would be answered. The record will give the answer itself. So that's why I'm not reading out the entire judgment or anything else. I'm just simply pointing out the relevant pages, which will be giving answer to my landed appellate court judgment.
So apart from these two, no other points.
The question is that in view of the fact that there is no adjudication of my right, so I am not affected by the doctrine of res judicata. Because no issue framed, no written statement filed, no nothing of the sort.
The crux is that you have been made pro forma.
Yes. And
Principal
explanation has been given. They approached me, I refused to part with him. I refused to accompany him. Even my status as a pro forma, because of the reason that they approached me, that means that they have admitted me to be co-owner. They approached me, I have refused to accompany them. That's why pro forma. So status of pro forma is very much clarified.
That has been submitted.
Yes. Now, another very important thing. I shall try to honor my lord's views. I shall not read out the entire thing. Certainly not. I cannot. Now because page 99 of the deed of 1939, standing in the name of predecessor interest.
This is not reopening on the entire issue.
No. This is very much on record.
Only cite 3 judgments on res judicata. That's all.
This is yes. On that score, I will be touching it. Yeah, certainly, of course. The kindly see this judgment. This is a reference in the record. It is nothing new in it. This is a part of the record. Now, in this 39 document, my title has.
Mr. Bhushan, have you been able to read out the entire page?
So that is Exhibit A in the original record. It is annexed. So the only thing is that there is a purchase of my person through whom I am claiming title. So it is my predecessor's title deed.
You are a co-sharer.
These 39 purchasers are the joint owners and nobody else.
You are also a co-sharer.
I am the absolute owner by virtue of this document. That is
Of the
very
entire-
significant.
of the entire property.
Yes. My friend was submitting on the last occasion that partition can be there, can be in case of question of partition arises where. But here, if there is no co-sharer, question of partition doesn't arise. This document has not been exhibited in the suit, but this document has not been challenged or set aside.
What is the exhibit number?
A. As per the record available to me in the record, this paper book is exhibit A. So if this part has been now not touched, this is exhibited document. Court could have held no, your document is not doesn't cover your claim. No discussion, no adjudication on that point. So if I am the exclusive owner, and he was the man to whom the other side is claiming title, he was acting as a caretaker. That judgment is we have referred. So,
Earlier, it was your submission that you are a co-sharer. Now
that is their plaint. I am a co-sharer is their plaint, not my plaint. My plaint is otherwise. That is the 39 document is their unchallenged document.
Your claim relies on exhibit A.
Yes. Document 39. 1939. That is available in page 23 of the appellate
Proposal. Let us now go through the judgments which you are referring. Let us now go through the judgments which you are referring. Apart from these points,
All right, I said I have almost come to that point. কিসের 23 কোন কিসের 23 টা কোনটা অ্যাপিল কোড না চাইল্ড কোড
clearly bola jaye registry kora hobe
But to assist your lordship, you might kindly take note of page 23 of the trial court judgment. This title question has been clarified.
paper book,
Paper page 23. This clarification is there. The trial judge was not unmindful of this issue.
second paragraph and third paragraph. In the written statement.
Yes. It's a judgment.
Yes.
Page 23.
Internal page 8 of the judgment.
Yes. So I mean to say the obscurity. The honorable judge is a human being. Maybe he just escaped the notice, or his notice was not drawn by us, the lawyers. In this page 23 is very relevant and clarification of the entire episode. Confusion is there. I am claiming 16 as owner on the basis of 39 deed. 39 deed has been marked exhibit. It has not been decided otherwise that no, this deed is void or voidable. No challenge of the deed, nothing of the sort. So long that stares at the face, you cannot go beyond that. If that be so, no question of partition. Partition has been sued. They filed 2 suits against, one for injunction, we have read out to your lordship. A second one was the partition. The partition suit filed by my friend's client is rejected. And they are also they implicated me as a party, which means they admitted me to be a part owner, not full owner. But my case is I am a full owner. If I am a full owner, if I have a better title than the occupant, I am entitled to a degree, even if not specifically claimed. Order 7, Rule 7. That part has not been clarified.
This is the entire stand of the appellant.
Yes, this thing was not properly clarified by earlier.
Now it has been clarified. Now,
Yes, the judgment will be there. এটা কোনটা ওদের সব দেওয়া আছে ওদেরকে সব দেওয়া আছে
তিনটে খালি দেখাবে 95 সুপ্রিম কোর্ট 2000 ভলিউম 3 আর 2000 ভলিউম 7
ওই বইগুলো দিয়ে দাও ভাই একটু বার কর
দেখাতে
ওদের কি দেখা যায় সেটা আমাদের দেখিয়ে দাও, ওদের যা দেখা করে রাখো। 68 Calcutta, we have cited lordship. And on the question of admission, these are just Mukherjee judgment.
কোথায় গেল যে রিটেন নোটস
Written submission দিয়ে দাও, written submission দিয়ে দাও।
দিচ্ছি বার বলছি।
এই তো এখানে রয়েছে।
এই টোটাল বান্সটা দিই।
This is the written submission.
Yes. 68 Calcutta, page 550. ওটা বার করো ভাই, বার করে দাও। So that is the judgment of Justice Vijay Chandra Mukherjee. If my memory doesn't fail, it starts at left-hand page, right-hand column. First 5 lines are: suits may come, suits may go, petition with or without affidavit, admission remains forever. Admission of fact made against one's own interest is binding, is estoppel. So they have, why I have citing this judgment? Because in their pleading, in their earlier proceeding, they admitted me to be a co-owner. So they can, at best, they cannot go beyond that. My case is full owner. The case is part owner. So, but that admission that I am a co-owner cannot be wiped out.
yes
Judgment of Justice Vijay Chandra Mukherjee.
yes apart from this 4 the other 3
Say 75 Calcutta, দেখো তো দেখো তো।
no these have been referred these 4 have been referred
আর একটু লাস্ট সাব যেটা দিয়ে দাও, ওইটা কেয়ারটেকারটা দেখে না, দেখো জজ সাহেব দিতে হবে।
18, 19, 43. Yes, ma'am.
So my another judgment I am referring, that is 2012, volume 6, SCC, page 430.
that has been referred.
Yes, paragraph 18, 19, 43. Head note B only, I am referring the head note B for the time being. Suit for maintainability, gratuitous possession, permissive possession, suit for injunction by watchman, caretaker, agent, servant, all of them being persons in gratuitous possession, permissive possession against dispossession by property on behalf of principal and acquires no right or interest or extended only to a person who has a valid subsisting lien. This is the ground, this judgment we have relied on, because they are in there, discussion is there in the judgments in the court below about the status of the defendant, that he is looking after as caretaker. If the claim says he is looking after as a caretaker, this judgment hits him. Yes, on the question of res judicata. That is 2000, volume 3, SCC, page 350.
This one is the 5th one.
No,
Yes.
this is not on record. This is subsequent.
Subsequent
This is along with the this list is there, I think the original bunch.
let those be furnished. The
It is was dekhi da.
entire 7.
It is. Earlier 1 to 5 and this the subsequent 3,
Earlier 4.
and subsequently they all are here.
Why 9 have been mentioned?
I think what
Let this be furnished. Mr. Kushal, kindly be seated. Let this one be furnished. The entire set be furnished.
ঢোকালি কেন ওইগুলো?
এইটা তো আছে 2003
2003 তে দেয়া।
2003 is already on record.
No, it's subsequent. Subsequent, you told me that you will like.
Last दिन 3 दिन
Yes.
ঠিক আছে, সামনে record আছে।
Mr. Basu, have you got the entire list? Not the photocopy of the judgment,
Written
but the list.
No,
of
not
the
necessary.
judgment.
Written submission.
No.
In the written submission, there are 4 judgments.
Provide them.
I have looked
Kindly
into.
provide them the
No. This
first 2 pages.
will not do.
Kindly provide them the first 2 pages.
এইটা একটা করে দিয়ে ফ্রি ব্যাচ করে দিয়ে দাও।
হবে না, আমি দেখে নিয়েছি।
Only the first 2 pages we provided.
Nothing to be provided. Here they have
We have not furnished.
At least the list of citations we
No,
provide.
no problem, no doubt about it.
Kindly see the thinner one.
Yes.
Thinner
AIR,
one, manually file
AIR,
4.
AIR 1968,
68, yes.
Calcutta 550.
Yes.
That is, I think, seventh one, seventh, eighth one, in the second page, topmost one.
Yes.
AIR 1968, Calcutta 550. Thereafter, AIR 1975, Calcutta page 200.
Yes, that is in my hand.
Yes, yes.
No, that has been
That is
furnished
there.
earlier.
Yes.
Next comes third one is 2012, volume 6, SCC, page 430.
It is nowhere. Oh, yes, yes.
No. After all, I will have to consider
Yes.
whether that is mentioned among the 9.
12, yes.
2012,
6 SCC,
volume
430.
6, SCC, page 430.
430.
The fourth one is 2016, volume 6, 2016,
No,
among 9.
no.
2016, volume 6,
Neither in
SCC.
this compilation nor in the previous one.
So which one to be
Well,
considered, Mr. Gocha?
I said 9. I shall confine myself with 9. The earlier 6 and this 3.
Earlier 4 and 3, 7.
7.
No, among the earlier 4, the fourth one is not enlisted.
No. Here it is not enlisted.
The 2016, which is
Not
written in
there.
hand.
Here it is not there.
যেটা করছো না সেটা ছেড়ে দাও এটা দিচ্ছ না ছেড়ে দাও না kindly permit me then to set the original list for four of the
4 and then 3.
let me do that. Second one I am handing 7.
Finally, Mr. Gocha.
Yes.
AIR 1968, Calcutta, page 550. You are considering. AIR 1975, Calcutta, page 200. Third one is 2012, volume 6, SCC, page 430.
It is nowhere.
I think it is there.
The eighth one in
I think it is there.
second page, topmost one. 2012, volume 6, SCC, page 430. And now the fourth one, 2016, volume 6, SCC 576.
করছি না
Are you relying?
No.
No. So let this one be struck off.
Yes.
Mr. Mondol, struck off the fourth one.
ছোট pen
2016, I think. 2016 volume.
That may be mistake on our part, but there no question of any hide and seek.
No. After all, it should be settled, finally settled. So here from 3 are there, three citations. Apart from these 3,
Last occasion, 3 judgments have been handed over.
now hand over that one.
কোনটা জলসাকে দিয়ে দাও এটা তো বাঁচ কেন অরিজিনাল যেটা দিয়েছি এটা তো দিয়ে দেবো
No, which you intend to give.
No, same thing. Maybe repetition, Modhikontu no sir.
No, that will be problem.
No, now, if we do not press for it, then this is not applicable. If I do not press for it, then it is not applicable. I shall confine myself to those.
1968, page 550.
It cannot be my intention to play hide and seek.
2012, 6, SCC. Yes. So 7, 8, and 9 earlier referred. Now we come to the first page of this one. There are 6 judgments. Which one you are relying?
2000 volume 3 SCC page 350.
2000 volume 3 SCC page 350.
Yes.
This is the fourth one. Thereafter,
এটা আর কি আছে? May I think do one thing, my
Hmm.
we have agreed to this that we shall confine myself to those original 4 and another last 3.
now original 3 remains.
3 remains, then the last 3, 6.
Six, altogether 6.
Yes, yes.
So
I shall confine myself to that.
be kind enough to struck out the others.
দেখে নাও ভাই, যেটা যেটা দিতে যাচ্ছে না যুগ ঢুকে সে ছেড়ে দাও, কেটে দাও, চিক দিয়ে দাও, বার করো। 99টা কি আছে, বার করো। এটা দিয়েছো, দেখা খুঁজছো তুমি? বুঝে যাবে, বুঝে যাবে। 28 আপনি চাইবেন দিও না, বসে কনফিউশন হয়ে যাবে। পেয়েছো? বাঞ্চের মধ্যে আছে।
5 নম্বরটা
এখানে তো পেয়েছি ভাই। 1990 এরকম 2000 ভলিউম 7 এসসিসি,
কত?
2000 ভলিউম 7 এসসিসি, পেজ 543,
সেকেন্ড দিচ্ছি।
প্যারা 10। And minus this 2000 volume 3 SCC 350 minor has got it.
99 ফুটটা
আর কি দিও না, ওইটা দিয়ে দাও, আর ওইটা দাও, এটা দিয়ে ছেড়ে দিচ্ছি।
বুঝে শেষ করেছো? উঠবো?
দাঁড়াও,
ওই যা আছে তাতে থাক, ওইটা থাকবে।
we have marked it. Paragraph 27 and 28 only.
So altogether how many? 5.
Yes, 3 and 5. Then
3 and 2, 5. 3 and 2, 5.
Yeah.
Remaining
and another one is going to page 1990 কত 95 1995 Supreme Court 1417
1205 এই তাই তো?
মেহবুব সাহেব,
মেহবুব সাহেব? হ্যাঁ ঠিক আছে, পেয়েছি।
চার নম্বর
number 4.
number 4. So now it comes to 6.
Yes,
3 plus 3.
that's all.
Remaining 3 are being struck off. এইবার দিয়ে দিন, বলুন ওনাকে বলুন
তিনটে দিন।
কেটে দিন, এইগুলো কেটে দিন। মিস্টার মন্ডল,
ভলিউম 3 আর 2000 ভলিউম 7
মিলে গেছে।
মিলে গেছে
জি।
তো মিললো, আর কিছু মিললো।
the remaining which you are not relying, Mr. Gosha,
Cross.
those be struck off.
So I shall be just to the remaining 3 I just referring, and that will be sufficient.
So altogether 6.
75 Calcutta page 200.
That has been referred earlier.
Yes, by paragraph 8.
Hmm. Yes. 50. Five. Page 410, 2000, volume 7, CC, page 543. So, Mr. Hoshan, first one is AIR 1968, Calcutta 550. AIR 1975, Calcutta, page 200. 2012, volume 6, SCC, page 430. Thereafter, 2000, volume 3, SCC, page 350.
Yes.
1995, Supreme, SC, page 417. And the last one is 2000, volume 7, SCC, page 543.
Yes.
So we are to be confined with
Yes,
this.
yes.
Yes.
What is about last to the line for 70? That's the one. Last one was, I think, the 2000, volume 7, page 543.
Yeah, page 543. Gram Panchayat of village Naulakha versus Ujagar Singh and others.
Yes, yes, yes. And there the principle was, for which I am relying on, the doctrine of res judicata is not applicable as because the earlier suit was for injunction only, as in this case. And no question of title was gone into or decided.
Mentioned.
75, I think I have not yet mentioned.
No, 75 has been mentioned in the original, earlier.
I have
No.
not placed before your lordship.
Yes.
That if the materials on record are there, court can mold relief under Order of Rule 7.
The
They are
response,
the relationship of landlord and tenant could not be proved, but the plaintiff was found to be the lawful owner. So, having better title, he got the degree.
the respondents are ranked trespassers as because they have no documents to show either ownership or any other right.
So I have a better title. So on better title, I will get the court has power and Order of Rule 7. And without repetition, that is 2000, volume 3, SCC, page 350, paragraph 12 to 14.
By 2000, volume 3, SCC, page 350, paragraph
12 to 14.
12 to 14.
12 to 14.
Herein you have mentioned paragraph 18 and 19.
That is additional paragraph. 12.
12 to 14.
Then 18 and 19. So these are we are relying on. Because there is no adjudication of my or substantive right, nor the deed of 1939 challenge either ways, no finding, no issue, nothing of the sort. So long that deed of 1939 prevails, so you cannot have any claim over the property as well as
That you have stated earlier.
Yes. ঠিক আছে তো? হ্যাঁ বাবা, ধরো। ছাব্বিশের লোক কিছু নেই।
I think court is tired, my lord, for settling the citations and the written submission. Number one point is very simple here. While admitting the order for your my lord, the question was before the court whether the landed trial lower appellate court is justified in not entering into the merits of the case only on the ground of res judicata. Res judicata is a point which prevented the lower appellate court from entering into the arena of adjudicating the matter in its factual aspect. This is the last fact-finding court. Now, my lord, the judgments which has been now cited before my lord by Mr. Ghoshal, so far as Justice Vijay Mukherjee's judgment, then my lord, the caretaker's right. Those are all on merits of the case. If the court can enter into the arena of adjudication, then those judgments on the facts of this case may be relevant.
First of all, we'll have to be confined within the three substantial questions of law.
No, I cannot
have
say, as an officer of the court, I cannot say when the my lord is deciding on question of law, you cannot look other points. You lordship can. But where it is such a point which close the door of adjudication on merits. That's why in this case, your lordships will not be, I cannot say entitled, lordship will not enter into the merits of the case because the first door is closed. If my lord is able to open this door, then your lordship can enter into the arena of discussing the matter on its facts. Whether there is a challenge, whether I have a right or not, co-sharer, these so-called ambition, all are not relevant for the purpose of adjudicating this substantial question of law in the second appeal.
According to you, the main entrance is closed. So we cannot go into the
Other points,
Other
because those judgments are mostly on merits of the case. I will not argue that. I have not argued that on my written submission also. I have not argued that because there is no scope to go into that question. The only question is, my lord, res judicata. My lord, let us, my lord, see, the trial court has one occasion that res judicata will not apply. Just now has placed before me.
the internal page 8 of the judgment.
Now, my lord has to see whether it is the duty of the lower appellate court. If the
First appellate court.
or first appellate court. Now, lower we cannot say nowadays. So, my lord was when my lord was in the trial court, my lord was marked as lower. Now, your lordship not. The first appellate court, my lord, has a duty to alter the finding of the first court and to come to an independent finding. Some judgment says if you are conquering, you need not give any specific reason for that. In some judgment says that even if you are conquering, you can give your own finding. But I will hurriedly, my lord, take your lordship just for my learned friend I decapitulate. I also try to decapitulate. Kindly take trouble to see the judgment of the lower appellate court.
Paper book page number.
You go to page number 1. Internal page 5. পেপার বুকের নম্বর কত?
69.
পেপার বুকটা কোথায়? প্রথমেই আছে 5, page 5. At this juncture, it starts with at this juncture. As well as Kali got it.
First appellate court.
First appellate.
That will be page 69.
Page
68 or no,
আরে এটা পেপার বুক, এটা কে পেপার বুকটা করেছে? This is not the paper book.
what's it? Judgment and decree of the first edition. Yes.
আরে পেপার বুক করতে জানে না যে করেছে।
Page 6. Internal page 6. Yes. Judgment of the first appellate court. Yes.
সত্যি এই পেপার বুক যদি কোথাও পড়তো না তবে ছুঁড়ে মারতো তোর জজ। First page is by a memorandum of appeal. I have never come across such a second table paper book.
So, Mr. Basu, you are referring to?
My lord, kindly come to এটা তো ট্রায়াল কোর্টের যাই। Page 6. এই পাচ্ছি না। 5. It starts at 6. Internal page.
Internal page.
Just a minute, my lord. 10 of it. In this context, at this juncture. I'm sorry, my lord, I'm taking time of your lord. At this juncture. Kindly come to page 8 of the
Page
paper.
8, yes, page 8, third paragraph. At this
At this
juncture,
juncture.
I would like to lay
May I place it?
Hmm.
At this juncture, I like to lay emphasis on the records of the title appeal of number 205 of 2010 between the same parties of this appeal being directed against the judgment and decree of such and such, fourth court Alipur, of a suit of declaration and permanent injunction. Kindly pause for a moment. The judgments relied upon by my learned friend or are res judicata in a case where injunction is the subject matter. In a subject matter of injunction, there may not be necessary, I say, use the word may not be necessary to go into the question of title. But in a case of declaration of title and injunction, declaration is a sine qua non to decide a suit. Trial lower appellate court, my lord, first appellate court, my lord, has taken pain to decide that distinction where there is a suit for declaration simpliciter and where a suit for injunction simpliciter. Simpliciter. My lord, may I proceed that? Of a suit for declaration of permanent injunction against the present appellant defendant in respect of the same property. In that suit, the plaint and judgment of decree of such and such were admitted in evidence. It reveals that in title suit number 24 of 1997 of the Civil Judge Second Court, the present defendant's appellant instituted a suit against the Devashish Ghosh and others, where Ananda Mohan along with others were impleaded as pro forma defendant. Well, pro forma forget what? Defendant. There is no pro forma defendant. In a suit, I have been made a party. Suit proceeded, meaning thereby parties have been served. In that case, if the question of title arises in that court, I am a mere spectator. It is whose fault? I should be blamed, none else. Keeping this fact in parallel, my lord, now the court is deciding, kindly come to.
So, why that paragraph? Relief is being claimed against the defendant number 1 only.
What is the point? Only, my lord, is getting. Only is not there. Only cannot be there.
Let that word be.
If only is not there,
relief is claimed against defendant number 1.
defendant number 1.
Degree candidate number 1.
No, please. Please. Please don't. You are gone. Question is, when a suit is filed against the defendants, and I am a defendant, served on me, and title is being decided by the court. There is no dispute that in that suit, title has been decided. And according to the defendant, this is his title is being decided by a court where I am present. Am I clear to my lord? I will not oppose and allow it the suit to be decreed. That's the question, my lord, where res judicata, Marshal has to decide whether res judicata will be there or not be there. Then, my lord, then come. Next para. The effect of a decree in presence of a pro forma defendant is to be discussed for the subsequent latter part of this judgment. What has been decided. Now, my lord, kindly turn over the page.
As regards to service, what has been mentioned in the judgment of the trial court?
My lord, so far as I did not say anything before, my lord. My lord has ample experience. If this service is not affected, what is the consequence? Can this suit is ready for hearing?
Nothing has been mentioned in the judgment.
Need not be. Presumption is served. Today, my lord, an appeal is before my lord. My lord has to first see the service and receive of lower court record. If these two are not there, this is not an appeal as regard ready for hearing. Today, I cannot say that it has not been served on me. Because court is satisfied, the service affected, that's why it is being ready. Otherwise, substituted service or at the claim of the plaintiff, it should be deleted. That can be done. But it cannot be said today that decree has been passed and a party has not been served. Then my lord, kindly come to the paragraph page 7. এটা কি হবে দেখছো?
Page 7 of the first
Kindly
appellate
come
court
to
judgment.
The judgment has been relied upon. Well, kindly see 2008 4 Supreme Court cases has been relied upon by Justice Chatterjee. Kindly come to that.
2008 4 Supreme Court.
Yes.
Page 9. Page 9 of the paper.
কি দেবো? But this is also unknown to me. A judgment relied by the court, I have to serve.
Basu is referring to the
The 2008 judgment relied upon
2008 volume 4
for
SCC.
SCC relied upon for which proposition?
It has been relied by the first appellate court.
Right. So I did not.
Actually, he sought for the copy, we gave him the copy. Incidentally, we didn't get any copy from this judge.
Which judgment?
Those you have relied that the respondent has
I have not relied any unreported judgment. All are reported judgment.
list of the judgments. List of the judgments.
Principle of law.
List of
Handed over a copy. Handed over a copy of my written argument.
Insufficiencyর সাথে তো আছে।
Written submission দেওয়া হয়নি?
দিয়েছে
বাস তাতেই আছে তো বাস।
তাতেই আছে, তাতেই দেখুন সব আছে।
দিয়েছিল এটা আমরা অ্যালিগেশন করছি না, ফ্যাক্ট ইউ টেলিং।
আচ্ছা,
কেন আছে? It was annexed with it.
Cannot be. I have supplied a copy of written submission.
in the written notes of argument, those citations have been referred to.
Certainly.
It's been given. Copy was also given.
আর না দিলেও যদি কপি নাও দিয়ে থাকে।
As the written notes of argument
Supplied.
supplied.
Yes. But kindly let us, we are digressing. My flow will go. What is the discussion here? By the first appellate court, in contrary to the res judicata which the trial court has found, no, that is not res judicata. What is the finding? But a finding on title cannot be recorded in a suit for injunction unless there are necessary pleadings and appropriate issue regarding the title. The Honorable Court further held, where there are necessary pleading recording title and appropriate issue relating to the title on which plead evidence, if the matter involved is simple and straightforward, the court may decide upon the issue regarding title even in a suit for injunction. It is going one step ahead. Here is a suit for declaration. Then, my lord, then another judgment was relied upon. Kindly turn over the page. After the judgment, it is settled law. It is settled law that in a suit for injunction, when a title is an issue for the purpose of granting injunction, the issue directly and substantially.
Mr. Basu,
My lord, 1994 AIR has been relied upon.
1994 AR SCC Supreme Court 152.
Yes. Then
Thereof.
it is settled law.
It is settled law.
It is settled law that in a suit for injunction, when title is an issue for the purpose of granting injunction, the issue directly and substantially arises in that suit between the parties. When the same issue is put in issue in a later suit, here the same thing. Based on title between the same parties or they are previous in a subsequent suit, the decree in the injunction suit equally operate as res judicata. Then another judgment has been relied upon. This 2000, just now my lord has relied upon 2000
volume 3
that has been relied upon. And what is the finding? Finding is a decision on the question of possession of is res judicata on the question of title to the extent that adjudication of title was essential to the judgment, but where the question of the right of possession was the only issue actually necessarily involved, judgment is not conclusive on the question of ownership of title. This distinction has been categorically made. Then kindly come to the bottom. Hey, Mafia Singh, chup kore boso. Chup. Thus, the decision on the question of possession in the jurisdiction of the question of title to the extent that adjudication of title was essential to the judgment in title suit number 24 of 97. This is my lord has to see. Prayer was declaration of title. So, my lord, decision of title was the main factor to be decided. Then the question of injunction court will come. Then, my lord, true, the decree of injunction was passed against the defendant number 1, But Anandamohan was one of the pro forma defendants in the suit, and that suit was decided in his presence. Kindly come to the bottom. Then the issue was framed. Then, in title suit number 24 of 1997, Anandamohan was a party to the suit, and the plaintiff therein, the present defendant, claimed themselves as co-owner of the suit property along with the defendant Anandamohan. In that suit, a right to relief in respect of the plaintiff's title in the suit property and definitively alleged to have been existed against Anandamohan, if he denied or instructed to deny their title therein, not only that a separate suit, being title suit number such and such, were brought by or against Anandamohan and or his successor in interest by or against the present defendant, such common question of fact arose as to whether the present defendant respondent had right as co-owner in the suit property or not. More so, in terms of Order 7 Rule 5, Anandamohan interest as co-suer in the said property was shown in the plain as title suit number 24 of 1997, and he was liable to answer if the plaintiff is that suit or co-owner in the suit property therein. Here, it is not for the merits of our case. It is this fact was recorded to substantiate what is in that suit.
Yes,
On
Mr.
merit also, my lord, the court has to some extent gone. Two lines I will place before my lord. It starts with the paragraph in this regard. I would further like to add.
In this regard, I would further like to-
Kindly come to that. Kindly come to the last three lines from that.
the appellant.
The appellants once decided had title in the suit property cannot be held trespasser therein. This is the question, my lord. The court has altered the finding of the trial judge so far as res judicata is concerned.
Yes,
Now, my lord, I have already cited two judgments for your consideration. These three judgments, which my learned senior friend has cited, my lord, I will only say so far as 1995 Supreme Court or the
on
is,
behalf
Supreme
on behalf of the respondents, 2000 volume 3
2000 volume 3, I need not say anything. The
It has
court
been-
has
it has
the
been referred by the first appellate.
first appellate court and discussed. This proposition, my lord, I have to concede. Proposition is well known proposition.
No, 2000 volume 3 SCC page 350 has been considered, and herein it has been referred to by both the sides.
Both the
For
sides.
appellant
But I
and the
am saying the proposition held therein is absolute proposition. But you have to
they are also relying on
relying on. But here, my lord, we are in a better position because the suit which was being sought to be raised as a res judicata as a bar is a suit for declaration. Had it been a question of injunction only, then I have to make more vigilant to see whether there was really any occasion come to decide the title, to reach, to give relief for injunction. But here is a case of declaration and injunction. So, declaration of title is must.
So according to you, as that was the case, seeking declaration of title and injunction, so the issue of title has been
Decided there in presence of Anandamohan.
has been fully and finally
Decided in presence of Anandamohan. That is the main thing. And so far as 2000 volume 7 Supreme Court 4543,
as he was a party, though let us take into consideration pro forma, he could have preferred
pro forma is nothing in the code of civil procedure.
in whose presence it was decided.
Whose presence? That's all.
He could have, according to you, he could have
Yes.
preferred anything
Yes. That's not
that he has not done.
done.
So it has been finally
Decided.
Then
there will be no end of any adjudication.
And the second one you have cited is 2008 volume 4 SCC page 594.
Yes. There, my lord, paragraph 13 to 21, my lord. Probably this judgment was also relied upon by the first appellate court.
Yes, this one is the first one.
Yes. That is the main judgment. So I have not done any homework. I only copied as usual. Then, my lord, kindly come to 2000, volume 7, Supreme Court 543. As Ghoshal has relied upon.
2000 volume 7
It is a
SCP
suit for injunction.
543.
This is a suit for injunction. Here, in this case, it may not be necessary to decide a question of title. And 1995 Supreme Court 1205. And
Then
1995 Supreme Court 1205.
Huh?
थोड़ा की देखिए उधर ये देखिए
1995 Supreme,
Supreme.
SC page 417.
Same judgment. There, my lord, will find
corresponding to
corresponding to 1995 Supreme Court, AIR 1995 Supreme Court,
AIR
1995 Supreme Court 1205.
1205.
Paragraph 8, my lord can read from the AIR. This is a question whether the res judicata or not amongst the co-defendants, not the plaintiff or defendant. Whether there is a res judicata among the co-defendant. We have nothing to do with this. This is not totally misplaced in the facts of this case.
Section 11 states that in a former suit between the same parties, whether it is a plaintiff, appellant, a plaintiff, defendant, that has not been stated.
Not stated.
Between the same parties or between parties under whom they or any of them claim
Between. A co-defendant cannot be a between. Between plaintiff and the defendant. Amongst the co-defendant, it cannot be without any quarrel. Then he has to be transposed. So for 1995, I can only say, my lord, that this is not judgment for our case because this is the decision amongst the co-defendants whether there will be res judicata or not. In title suit 24, he was a defendant, and his presence, his title, if we say his title has been adjudicated. Whether he will be allowed to, my lord, raise the same point in a subsequent proceeding. Any query from my lord?
No. So you have dealt with all the three. Have you dealt with 2003? You have referred to, not
That is referred.
Already referred.
That's all. Or kichu?
Similar law is always the same.
Yes.
But the application varies on fact is particular case. That is factually, my friend's guy is helpless. My friend with his sound voice is saying something, but his client hasn't helped him.
Heard Mr. Ghoshal, the learned senior counsel, and Mr. Basu, the learned senior counsel. Heard Mr. Ghoshal, the learned senior counsel, representing the appellant, and Mr. Basu, the learned senior counsel, representing the respondents. Exhaustively, full stop. The argument on behalf of both the sides is concluded. to serve, reserve for judgment.
আমি পালাবো
Reserve for
এখন।
judgment.
Here I am a co-defendant. My friend's submission. Here I am a co-defendant.
Admitted.
Probably then matter is over. Probably I don't make myself clear to Mr. Ghoshal.
Maybe I have informed understanding.
Grateful.
আচ্ছা, এগুলোকে এনভেলপে বড় এনভেলপে রেখেছেন, ঠিক আছে? পরে গোছাবে। Where is Mr. Haldar?
Why not fix the date in his presence?
Where is Mr. Haldar?
My learned associate called him twice with number. He's not picking up the phone. But it was a my lord's query. And my learned friend is not contesting that also. He says it has no effect. Same.
ডিসপ্লে বোর্ড ঠিক আছে তো? ডিসপ্লে তুই করে দিয়েছেন?
In fact, as fell from your lordship while preparing the judgment, point struck your lordship.
That was the last point. What is there?
Junior is here. ফোন করে কি ফোন তো তুলছে না। Could we start, my lord?
Why at the fag end of the argument, why to disrupt the
Equilibrium, yes.
equilibrium?
Then kindly,
Can-
kindly make it pass over. Let us
Yes,
see. Let us
it
see
will be
what-
passed over.
I'll try to contact.
Let an attempt be made.
I will make an attempt in 1 second. 1 second, I will make an attempt.
এটা পাস ওভার था নেক্সট দেখুন।
I beg to appear on behalf of the respondent, defendant respondent. On earlier 2 occasions, plaintiff appellant started argument. And on the second occasion of their argument, well, they have already completed, but
Mr.
judgment of
Sounabh-
affirmance,
Mr. Sounabh Mondol and Mr. Anirban Saharay.
Shaunak Bhattacharya. Shaunak Bhattacharya.
কি টাইপ করেছে?
Shaunak. এই ভট্টাচার্যকে মন্ডল করা যায়। Trend is very bad. This trend is very bad from Bhattacharya to Mondal.
That is
Well, judgment of affirmance.
that is not the factor. The factor is the appearance. The judgment of affirmance is not the factor. Appearance of the appellant is the factor.
মুশকিল হয়ে যাচ্ছে।
We had the opportunity for the entire day
Yes.
passed over. Next. Make an attempt to inform me.
Yes.
How the name also pointing great, it's not picking up the phone. Maybe keep it for 6 0 this. Right.
No, it is being fixed at 2 p.m.
Don't you?
Let an attempt be made because we are at the end of the argument.
Yes.
Hmm.
Rose,
Let it-
both sides have
Let the item number 2 be fixed at 2 p.m.
on Miller on.
today
Oh,
to 2 p.m.
it is.
Item number 3 also thereafter. I shall inform accordingly. if possible.
4. Mr. Banerjee, you are representing the respondent.
Representing the respondent.
Respondent
But
number
in-
1.
Respondent number, full respondent. Yes, one is full.
No, there are 2 sets of respondents. One is respondent number 1 and the other set is respondent number 2A and 2B. Who is representing the respondents number 2A and 2B?
Lord, I am telling your lordship.
Hmm.
From the memorandum of appeal. Cross appeal. No, cross appeal and no memorandum to that. Lord, I am for the respondent number 1. 2, 3 and 4 did not contest the proceeding in the trial court and the appeal court.
No,
Plaintiff-
before this court, one Mr. Pritam Chaudhary
Yes,
appeared on 10th of July 2024 on behalf of the respondents number 2A and 2B.
2B.
2A and 2B.
2B, very well, my lord. And respondent number 1, Lord, who is the plaintiff in the suit? Because in terms of the degree, if your lordship kindly come to
Mr.
page
Banerjee,
150,
Mr. Banerjee, in the absence of the appellant,
but my lord, your lordship may be pleased to fix it at 2 p.m. so that we can intimate them.
already a matter.
Already a matter, but we do not know, my lord,
Yeah.
what will happen. What would be the fate of those 2 appeals?
Nobody
in the
knows.
event,
Nobody
nobody knows. My lord, in the event, my other side
Sir,
comes here.
So first, 2 will be called item number 2.
Thereafter
item
this.
number 3.
Thereafter
Thereafter,
4,
item number
5,
four.
6. 4, 5, 6
Yeah.
same matter.
2, 3, 4.
4, 5, 6 matter.
Hmm?
4, 5 and 6. 2 appeals.
Yes, 4, 5,
One,
4,
yes.
5 and 6.
4, 5 and 6.
পরে ডাকি।
2 p.m.
শুনুন, দুটোর সময় প্রথম আইটেম ডাকবেন হচ্ছে আইটেম নাম্বার 2, তারপরে হবে আইটেম নাম্বার 3, তারপরে আইটেম নাম্বার 4, 5, 6, ঠিক আছে?
Item number 7.
ওদের 4, 5, 6 দেখিয়ে দিয়েছেন তো? দিচ্ছে না কেন? মুছে দিতে গেলে বুঝে যাবে। পক্ষ না থাকলে তো আস্তে আস্তে করে লিস্ট আস্তে আস্তে লিস্টটা রাখুন।
Number 8.
ঠিক আছে দেখে নিন, ঠিক আছে, এখানে তোলবার দরকার নেই, ঠিক আছে, যেটা যেটা হিয়ারিং হবে সেইটা রেকর্ডটা দেখে নিন। আস্তে 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 তাড়াহুড়ো না, আস্তে ধীরে ধীরে করবেন।
Item number 9.
Item number 9, I pray for not today, my asking Motilal, he has not come to due to his absence.
Not today. No. None is for the respondent. Not today. Not today. Not today. Not today. Deal.
Item number 10. Item number 11.
Mr. Dev Sharma, Lordship, is the advocate on record. He is representing 234.
Respondents number 2, 3, and 4.
Mr. Dev Kumar Sharma is the advocate on record. I am representing him. The paperwork has not been supplied yet, Lordship.
No, I am not.
Oh, you are
11.
talking against 11. No, whatever.
Because we had gone to the second appellate office also, Lordship.
এটা দেখুন তো ট্রায়াল কোড রেকর্ড
পাইনি
এখনো, ট্রায়াল কোড ফার্স্ট অ্যাপিলেট কোড রেকর্ড এসেছে, রেকর্ড তো নিশ্চয়ই এসেছে, নাহলে চলে এসে হিয়ারিং এ পড়বে না, হিয়ারিং এ পড়বে না। পেপার বুক এনে আছে আছে এখানে পেপারগুলো এখানে থাকবে না, পেপারগুলো এখানে থাকবে, এখানে সেকেন্ড অ্যাপিলের অর্ডার শিট থাকবে। The respondents number, এটা হচ্ছে এসে 114 years. The respondents are being represented by Mr. Oyon Banerjee, Mr. Dev Kumar Sharma, and Mr. Suman Banerjee.
Lordship.
Yes,
2, 3, and 4.
yes.
Mr. Dev Kumar Sharma is the advocate on record, Lordship.
On earlier occasions, what you have mentioned just now, that has not been submitted. Neither on 7/11/2025 nor on 24/4/2024. order করুন, নাহলে হবে না। order করুন। None is representing the appellant. Paragraph. The learned advocate representing the respondents submits that paper book, copy of the paper book has not been provided to him. Full stop. Paragraph. In such a circumstance, the appellant is directed by the learned counsel representing the appellant is requested to provide a copy of the paper book এখানে পেপার বুক আছে? পেপার বুক আছে এখানে? পেপার বুক নেই? পেপার বুক ছাড়া পেপার বুক ফাইল হলে দিয়ে যাচ্ছে তো? এখানে ডিপার্টমেন্টে ফাইল হয়, বলুন যে পেপার বুক যেই ফাইল হচ্ছে বা পড়ে থাকে, কিন্তু ফাইল হওয়ার প্রশ্ন নেই, যদি পড়ে থাকে সেগুলো যেন সব পাঠিয়ে দেয়, মনে করে বলে requested to provide a copy of the paper book to the learned counsel representing the respondents immediately. Let the matter appear on next to 9th of January. 9th of January 2026. Next.
Item number 12. Item number 12, Madam my lord, I am to the appeal. And this is judgment against my lord, diversion my lord. Trial court my lord,
Decreed.
dismiss the suit.
Dismissed.
Then my lord, plaintiff
Reversed
preferred
verdict.
appeal. And in the appeal my lord, the judgment reversed. And there are plaintiff's case my lord, they are titled by adverse.
But where is the respondent?
Then my lord, you lordship kindly, in the absence of other side, you
Matter cannot be taken up, but at least there should be someone to represent.
right, your lordship. My lord, they are all,
Paper book.
my lord, we shall inform, they have earlier appeared.
Yes, yeah,
We shall inform my lord, and my lord on. My lord, next,
Mr. Kumar Jyoti Tiwari is appearing on behalf of.
I shall inform. And my lord, I will also, my lord, concisely argue to your lordship, and my lord, prepare my lord notes of argument, I shall hand over to your lordship.
Can an attempt be made?
No, not today, my lord. Today, my lord, past day, my lord, your lordship kindly excuse me, my lord,
Court has to write up 3:30.
and possibly 3:30 court will be.
It is now just 4 minutes past 12.
Wait over. First day, my lord, you should stop with relaxation.
Not today.
My lord, only one thing, please, my lord, on the last, coming Friday, I will not be here. Friday week, my lord.
Learned senior counsel representing the appellants,
With Mr. Gotmaya.
provide the names, representing the appellants, seeks an accommodation for this day and uh, submits that let the matter be fixed on
I do it.
16th of January. 16th of January. Full stop. None is representing the respondents.
Try to be.
Full stop. Paragraph.
Okay.
As per the submission of the Sure. Let the matter appear. Let the matter appear on 16th of January 2026. 16th of January.
It would be possible first week of February, my lord.
The long.
And in the meantime, well, I shall prepare notes of argument first week of February.
Let us
If there been any difficulty, my junior will
No.
mention.
notes of argument can be provided during the first week of February. Let the argument be commenced.
If any difficulty, my lord, my brother will, my lord, mention. And my lord, for the first day, my lord, happy New Year, my lord.
Yes, it has already been stated. Happy and prosperous New Year to
All, my lord.
all.
All.
Happy and prosperous, both.
Extreme senior, my lord, is here. Develop the জিল্লা সময়
Order next.
দাদা তুমি যখন আছো তুমি সবার জন্য
But my purchase
For the
was prior to that. Your lordship kindly look to the order sheet.
Mr. Banerjee, for the respondents,
Lord,
For the-
we are for the all the respondents. All the respondents other at the time of
for the respondents and nobody for the appellants.
body for the appellant, your lordship kindly look to the order sheet. They will not appear because my purchase is earlier purchase. Their purchase is subsequent purchase. That is why
That
both
will-
the courts
that-
below.
That will be decided
Yes, yes.
at merit.
And my lord, in the Supreme Court judgment on order 41 rule 17, in the absence of the appellant, it can be disposed of on merit. I have brought that judgment. Lordship.
It has not ripened now. None is representing the appellants. Full stop while the full stop while the respondents are being represented. Full stop. Mr. Banerjee, learned senior counsel. And submits that the matter can be disposed of on merit. Full stop. Paragraph. This being the first day of after reopening, after the winter vacation, let the matter appear on 9th of January 2026. 9th of January.
And item number 1, my lord, so that it can be disposed of, my lord. Otherwise, every time, my lord, they are taking adjournment.
Each and every matter will hold its position accordingly. No upgradation.
But my lord, my matter was on the upgradation stage.
Hmm.
And second two matters, my lord, were in the down stage. But these has been gone to the down.
No, because
Because they have taken adjournment and computer,
no.
it is listed, it is being listed on
Their
computer.
Their matter had already commenced. Argument has commenced.
Yes,
That's why it has come above all.
that is why. Lord. No, that I know, my lord.
There won't be any
No, that we know, all
bypass
of
and
us. That we know, all of us.
overtaking of
All of us, we
any
know that.
matter.
Yes. All right, my lord, let it be on that date.
9.
Lord, so that no further adjournment on that date, no further
that-
accommodation.
Let
Because
the-
your lordship's order was,
let the matter come up on 9. The learned counsel representing the appellant is directed to be present on the next date.
lordship. Item number 15.
Next.
Item number 16.
Report. Document.
Item number 17.
Well, I am for the defending. Well, I am for the
Civil revision.
civil division. I do not know why it is happening as application, but because the matter was heard and it was dismissed on contest by Honorable Mr. Justice Proceed Prakash Banerjee. Thereafter, after 2 days, his lordship on his suo motu recalled the order, and the matter is pending before my lord. Lord, I have taken consent. Will your lordship take it on 9th? My lord. Matter was dismissed, my lord.
You are referring to the order dated?
The order dated passed by Honorable Mr. Justice Proceed Prakash Banerjee. Your lordship will get it on the file.
Is that everything will be in the file?
Yes.
The order dated.
Okay. At present is not with me.
14th February 2020, the order of
Was recalled.
recall.
14th February 2020, it was recalled.
Yes.
Because according to
There
his
was
lordship, there
direction
are some points to be argued. Lord, kindly take it on next.
As the order dated February 12, 2020 was passed on a wrong assumption,
Yes.
so it was recalled on 14th February 2020.
And the matter is pending, my lord.
Yes.
According to
That is the crux of the issue.
well,
Matter is pending since 2020,
20.
and the matter is of 2019.
Yes, my lord. That's why I'm not. Injunction
So let us start now.
my lord, kindly take it on 9th.
You are the advocate on record.
I'm, that is my lord. To be very frank with you, my lord, today I'm not ready. To be very frank with your lordship, my lord. Next night I shall do it. Can you fix the time? 2 p.m. I shall do it.
What is the issue involved?
Issue involved, my lord, that in an injunction application, while the learned court below referred the matter under section 23 of the Land Reforms Act, whereas it appears that this opposite party prayer for Borga has been rejected.
Prayer for?
Borga, recording Borga has been rejected. This is the class issue, my lord. This is the main issue, my lord. After rejection, whether the matter can be referred under section 23 while hearing an injunction application. That is the main matter.
We cannot comment today.
Well, next night, today the first day, well,
I have got the brief.
only night, well, at 2 p.m. Very short matter at 2 p.m. Well, I'm praying apology, well, for taking time, but only for today. Both he is also asking for time. 9th, well, at 2 p.m. I should do it. Very short matter. That is the main
Have
issue.
you represented earlier?
No,
No.
This is for the
Earlier
past-
advocate died. Earlier advocate died.
The earlier advocate died pursuant to the solemn direction passed by the coordinate bench.
Change brief.
Change brief, no, because the fresh service has been effected on opposite.
As per order passed by Justice Chatterjee.
Justice Chatterjee.
Chaitanya.
On 30th June 2025.
Has the Vakalatnama been
My
filed?
lord, it is with me. I am yet to file. Not I have got the Vakalatnama.
I'll go to the
The department.
I'll file in the department.
During the course of this day,
Certainly, ma'am.
the learned counsel representing the petitioner is present, full stop. Yeah, that's it. After 11, learned advocate submits submits that he has the wakalatnama with him, which he shall be filing within the course of this day before the department. Full stop. Paragraph. On the submission of the learned counsels representing both the revisionist and the opposite party, the matter is being fixed on 9th of February.
No, 9th of January
9th of January.
at 2 p.m.
Learned counsel, time cannot be fixed. It will appear in the list on 9th of January.
At least at the top, at least before appeal.
What is the use of
Item number 18.
whenever it appears, whenever it is called, the court hopes that everybody will be present, both the sides will be present to have the hearing at least.
Great.
So
আমি হচ্ছে opposite party.
Extremely grateful.
let the wakalatnama be filed today.
Certainly.
Grateful.
Next.
Yes, Malak.
এখানে learned counsel. After completion of hearing, next up.
Directed us to serve the notice to the learned advocate for the response. Learned advocate for the appellate.
No notice, there was no direction to serve a notice. You can serve,
Yeah.
you can serve,
Just I will take the name of this.
but not now, during the course of the day. After the completion of hearing,
That's why.
oh, acha.
Just I will.
Next item.
18. Yes, my lord. I am for the petitioner, my lord. It is my affidavit of service is there that this matter has been mentioned here. And my lord, the track result shows that, yes, that is a dismiss for default, my lord. It is a transfer brief, my lord. The advocate on record died in corona disease, and for that reason, he could not appear in and the matter was called on 22nd May 2024. And that I have annexed
Learned counsel,
order.
learned
Order, my
counsel,
lord, page 15. Page 15 is the order. Dismiss for default. Yes, my lord, service.
yes, as regards to service,
Yes, my lord, all respondents. All
where
respondents.
from the court,
All opposite parties.
where from the court will get that it has been served.
Yes, delivered, and later on, thereafter that postal receipt is there and track result, and then again I have obtained the track result.
Why are you providing a loose sheet? You have provided this one
In
affidavit
the
of
course
service.
of day, I shall submit my lord that with shewing. Nothing but.
Learned
Later
counsel,
on, I have obtained.
learned counsel, you have sent the notices
All opposite parties.
to
Four
four
opposite.
opposite
Yes,
parties,
yes.
whether they have received or not.
Yeah, deliver
from?
item delivered, that has been shown in the earlier. Later on, I have again obtained the track result.
From which page it will reveal that it has been delivered? The
Yes, my lord, this paper also shows that is why I am shewing. Just I am hurried, and for that reason I could not shew it today. My clerk has not come. In the course of the I shall shewing this.
affidavit is dated. Affidavit is dated
I
Yeah.
have completed that,
Dated?
when I have, yes, my lord, that affidavit of service, my lord.
It is dated?
Yes,
4th of December 2025.
yes, my lord. Thereafter,
Nearly 1 month ago. Nearly one month.
thereafter I obtained, again I have obtained the track result.
Where from it will reveal that
Delivered all,
delivered?
yes, my lord.
Where,
Yes,
where
my
from?
lord, my lord, my lord.
Where from you show?
I'm checking. In the first page,
Hmm.
08, last number, the Sikishko code, and in the left hand side, item delivered, 25th November.
Uh,
At the bottom,
item delivered where?
item delivered to the opposite party, my lord. That is the from the Sikishnopur BO branch office at the bottom.
It is mentioned to the addressee. Is it mentioned to the addressee?
They have, my lord, what can I do, my lord? Then I may obtain further, or otherwise I have no hand, my lord. The post office has item
Only thing
delivered.
from
Uh,
this
and
Learned Council,
yes,
only thing to be stated from this end is that whether this one reveals that the item has been delivered to the addressee.
my lord, then if ask me, my lord,
Hmm.
then I can come Monday and I shall try again. I shall try again if the postal printed such like same. I cannot nothing do, my lord, upon the postal service.
No. The Learned Council representing this civil revision,
Yes, ma'am.
representing the petitioner submits an affidavit of service. From the affidavit of service, it does not transpire. Let the affidavit of service be kept to the record. Full stop. From the affidavit of service, it does not transpire that the item has been delivered upon the opposite parties. Full stop. In such circumstance, the Learned Council is requested to serve afresh upon the opposite.
My lord,
the
once
opposite
try
party.
again, I can obtain if it is mentioned. No further service is required, my lord.
No, at this stage it cannot be. You will have to make a fresh attempt.
Further service.
Further step has to be taken afresh.
Good man, that will be a
So-
cost of
So why didn't you obtain the that report yesterday? That could have made the picture clear. To take a fresh step upon the opposite parties. Directed to take fresh step upon all the opposite parties.
If I may,
Address. How many days required? What is the address of the respondent? Opposite party.
North 24 Parganas, means, my lord, the Habra PS and Amdana PS.
Ashoknagar.
Also Habra PS.
Ashoknagar,
PS and Amdana.
Abra, Amdanga, and Ashoknagar. How many
North
days?
24 Parganas.
How many days? Fortnight.
This week, at least 7 days.
Okay, let the matter appear on 2 on 30th of January. It-
2 weeks after 2 weeks.
16th of January. 16th of January.
16 on my personal inconvenience, my lord, to 17. Or any earlier 15. Or
The Lord Council, this bench is available mostly on Fridays. That's why.
Sorry, 23rd, my lord.
23rd is
Oh,
yeah.
holiday, holiday. Yes, holiday.
30th.
Actually, my lord, 30th. Oblige me.
Okay.
My lord, if I obtain further today, that address, it has been written.
That opportunity has gone. 30th of January. Finish 30. Next.
Item number 19.
For the appellant.
Minor, I am for the respondent minor. The matter has appeared at my instance, minor. The paper book has been filed out of court at my cost, and in the meantime, the matter is due to appear under the heading hearing. And in the meantime, I have been told by my client that one of the appellants died, expired, and there is no other application which is pending to be disposed of.
That's why it is coming up.
Applications pending. One lot.
Jan 1 of 2019.
19, that is an application for addition of party. There was a
That copy, my
the appellant, kindly allow me to say. Lordship, there was an earlier direction that application will be heard along with the appeal.
Addition of party.
Yes, because that is the dispute. Here, Lordship, what happened? I filed a suit for partition and declaration.
So that has been, the issue has been settled. That
No, what happened, Lordship? So there was
wide order.
Lordship, the last order. By my Lord Justice Bibhash Ranjan De. Lordship, that will be 7th of February 2025.
No, last order is dated 29th of July 2025.
Yes. This order was passed by my Lord Justice Bibhash Ranjan De, dated 7th of February 2025.
7th of February.
Yes.
এগুলো স্টেপিং না থাকে খুব ভালো অর্ডার শিটগুলো ঠিক করে রাখবেন বুঝেছেন ছেঁড়া দেখে নেবেন বুঝেছেন Yes, 7th of February 2025. Paragraph
Lordship, there was a direction that
number 2.
yes, the application for addition of parties will be heard along with the appeal, Lordship.
Both the learned counsel appearing on behalf of the party appeal rather than on the fact. Both the learned counsel appearing on behalf of the parties to this appeal are heritable of the fact that the prayer of the instant application involves a substantial question of law identical with that of the appeal pending before this court, and accordingly both the learned counsel have prayed for hearing of this application. Being Can 1 of 2019, old 1189. 11889 of 2019 be taken up for hearing along with the appeal.
Yes.
This one is the first one.
Yes. And now is Can 2 of 2025. That is Lordship, appellant number 11 died.
You are referring to appellant number 11 only?
no. I am appearing on behalf of all the respondents.
Among the respondents, somebody has.
No, appellant number 11 expired.
There's
And my lord,
there's already an application.
Yes.
yes, the copy of application has just now been served upon me, along with the setting aside abatement.
Let us submit.
Lordship, it was affirmed on 24th of December, Lordship. So today it has been served in the morning. This
And
is
sitting as
It has been filed in the department. Not
Yes.
yet filed.
Yes. File, Lordship. Can 2. That is appearing in the list, Lordship.
Appearing in the list. 24th of December.
December, on the last day. I do not know whether it has been tagged with the
That
file
is
or
the
not.
question mark. আচ্ছা দেখুন তো শুনুন এই যে অ্যাপ্লিকেশন যেগুলো আসে এগুলো কখন রেখে দেন না সঙ্গে সঙ্গে ট্যাগ করে দেন? না না, সঙ্গে সঙ্গে বলবেন পাঠিয়ে দিতে, আর যখনই আপনি থাকবেন তখনই রেকর্ডে। হোয়াট ইজ গোয়িং অন? ওখানে যেন কেউ না থাকে, হিয়ারিং যখন হচ্ছে তখন পিন ড্রপ সাইলেন্স থাকবে, ঠিক আছে? যখনই আসবে ওইখানে বারণ করবেন রেখে দিতে, বলবেন রেকর্ডে গেঁথে দিতে সঙ্গে সঙ্গে। নিন, 10-2 is not yet.
Lordship, then let it be tagged, Lordship.
এখানে এখানে নেই তো, এখানে নেই তো, দেখে নিয়েছেন?
My lord, prayer has also been made to the extent regarding setting aside abatement of the appeal in the same application, as well as substitution.
Yes. Court fee for both of them has been given. It's a composite application.
Beyond 150 days,
No, beyond 90 days, but within
Beyond 90 days.
150.
within 150 days.
Yes.
The learned counsel representing the appellant or appellants
Appellants.
submits that the who has expired,
Appellant number 11,
appellant number 11, namely
Rishikesh Das.
Rishikesh Das, HRI
HRI.
Rishikesh Das has expired on
September 12, 2025.
and to that effect an application has been filed being can 2 of 25, full stop, copy of which full stop. The learned counsel representing the respondents
Yes, all the respondents.
submits that he has received a copy of the same just today. Full stop. Do you intend?
My lord, 7 days time may be given.
What?
My lord, if any evidence is to be given on behalf of the respondents, I am paying 7 days time only. And after the lapse of 7 days time, the matter may appear as your lordship will direct accordingly.
To that effect, an affidavit in opposition is required.
My lord, then it is your lordship's pleasure to pass necessary order.
কি হলো? কত হয়েছে? Just today, full stop. On going through the record, it transpires that the said application is not yet tagged with the record. In such circumstance, the department is directed to tag the said application with the record. Full stop. Let the matter appear on 9th of February 2020.
February.
January.
9th of January 2026. 9th of January.
As marked for, my lord? As marked for hearing, my lord?
Application under the hearing, under the heading application.
Marked. And in the meantime, if necessary, I shall file affidavit.
তাহলে ওখানে দিয়ে দিন, ওই যে learned counsel representing the respondents, ঠিক আছে? Just today বলেছেন, he further submits that if necessary, he shall be filing an affidavit in opposition to that effect. Full stop. তাহলে paragraph one. If an affidavit in opposition is filed, then a copy of the same
Yes,
will be
yes.
furnished to the learned counsel representing the appellants at least 2 days prior to the date of hearing.
My lord.
So on 7th it be furnished.
Yes. And on 9th, it will appear as marked for application, my lord.
Application.
My
Unless he is substituted, he or she is substituted.
My lord.
we cannot take up the hearing.
Cost
Apart from-
title is to be corrected.
Apart from that, no other application is
Only
pending.
that application for addition that has to be heard along with the appeal.
And
Not along with the appeal, my lord, only the application be heard. And after the disposal of the application, let the matter be heard as marked for hearing.
she is referring to the can one of 2019.
Yes,
19.
can one.
That will be taken
Yes.
up along with the hearing. Substantial questions of law,
Has been formulated.
Formulated.
order dated. Why is the brief?
Or in fact, the brief is lying with my learned.
The order dated 7th of January
2020.
2020. Yes, Lordship.
Whether the Court of Appeal below was justified in dismissing the suit and affirming the ultimate decision of the trial court. Affirmance.
Yes, my lord. Judgment of affirmance.
In dismissing the suit and affirming the ultimate decision of the trial court on the premise that one of the parties has been left out,
Yes, Lordship, by mistake. I added him, but in the appeal he was left
has
out.
been left out in a partition. suit.
That is a
Added him,
question.
before the trial court. He was
Oh,
there.
he was there, but Lordship, what happened initially in the appeal in the trial court, they took a point that one Jew Thakur was a necessary party. So accordingly, we added
They both the property.
their
Yes, my lord.
Lordship a point, Lordship. So we added him. Thereafter, Lordship, appeal was decreed. Against that, they preferred an appeal. Now, Lordship, it was remanded. Now we preferred a first miscellaneous appeal before this honorable court. At that stage, Lordship, that Jew Thakur's name was, Lordship, not added.
That
Thereafter,
is not in the order, that is not in the record, my lord.
Yeah.
And when the matter will be heard, it will be decided by your lordship whether the necessary party has been added or not.
thereafter it was.
And I will satisfy before your lordship that the substantial question of law that has been formulated will be decided accordingly.
So he was originally made a party, but by mistake,
That question cannot be
that
adjudicated now.
it is not being
Yeah, no.
adjudicated now.
We are not going into the merit at this instant
My lord.
moment. Was added by an order of the trial court. Though not implicated in the memorandum of appeal. In fact, such party was added by an order of the trial court,
Yes,
though not included in the memorandum of appeal filed before it.
yes.
In fact,
That is
ample
the-
opportunity was given by both the courts below, and that has been reflected in the order against which the present appeal has been preferred.
To amend the pleadings and include all the joint properties. And the second substantial question is question of law is that dismissed for that whether the suit for partition should be dismissed for non-inclusion of some of the joint properties.
Yes. Common hodgepodge has not been joined.
The court ought to allow the party to amend the pleadings. Both the
Yes.
parties and property. What remains?
But then, Lordship, again another round of litigation will go, Lordship.
That's a different thing.
Yes.
That will the ninth January, under the heading application.
My
Ninth
development.
Yes. Any little.
Item number 20.
Item number
20.
20.
My lord, defendant appellant, my lord, in a suit for eviction, my lord, the
First of all, why SAT? Can 1 of 24.
my lord, can one of
2 of 24.
Can
Can
two-
3 of 25.
3 of 25 was the substitution petition, lordship has allowed. My lord, the original defendant has died. My lord, he is substituted by his wife and his son.
Incorporated, the names have been incorporated.
My lord, Lordship had directed the department, my lord, to do the
মেমো বা বিল, মেমো বা বিলটা ইন্টারপ্রেটার করেছে।
But one is the application for stay, two is the application, one for the condemnation of okay?
না ওয়ান হচ্ছে তোমার স্টে,
Stay.
টু হচ্ছে কন্টিনিউশন অফ ডিলে, থ্রি হচ্ছে সাবস্টিটিউশন অ্যাপ্লিকেশন।
Nandolal Kurmi
But he
has
was the
expired,
original defendant, he died.
substituted by Chaya Kurmi, wife, and Vishwajit Kurmi,
My lord,
son.
son,
So as regards to substitution, it is complete.
Lordship.
Now,
My lord, there is a delay of 642 days, my lord, in preferring the appeal.
so, can 1 of 24.
But that is can 2 of 24.
Can 1 is stay,
Stay
application for stay.
Stay,
Can 2, condonation of delay.
Lordship.
$642 days.
Lordship.
Paragraph.
My lord, I have stated that, my lord, in paragraph 19, page 6, and the calculation is also given.
What you have stated.
Now, my lord, what had happened here was, my lord, it's a judgment and decree of reversal. My lord, the suit court dismissed the suit for eviction, appellate court, my lord, reversed the decree.
Suit for eviction.
Suit for eviction. I was
Tenant.
tenant. Now, my lord, this I am the tenant.
Tenant.
My lord, the original defendant, Nandolal, was the tenant. Now, my lord, Nandolal, my lord, the suit was filed by my learned friend's client. The
Suit file dismissed.
dismissed. My lord, the learned friend's client, my lord, preferred an appeal before the learned lower appellate court reversed the decree. Now, my lord,
Eviction
kindly,
decree was passed.
yes,
Has been passed.
that has been passed. Now, my lord, my grounds are, if your lordship kindly, my lord, takes up, my lord, for my 642 days delay, kindly comes to paragraph 10 onwards, internal page 4.
Have you filed?
Yes, my lord, they have filed
Giving
opposition.
reply?
There was a direction to file, my lord, file my reply.
Copy served?
Yes, yes.
Yes.
Now, my lord, kindly comes to paragraph 10.
10.
Yes.
Hmm.
Now, my dear petitioner states that since he is an aged ailing person, my lord, Nandolal at the time, my lord, was about, my lord, when he died in 2020, my lord, lordship would get it from a substitution application at the time of his death. My lord, Nandolal was, my lord,
25.
20, my lord, 63 years, my lord, on 2025. So, my lord, he was 64 at the time of, my lord, yeah, when he had filed this application. Now, my lord, kindly comes to paragraph 10. My lord, my first ground is, my lord, the judgment and decree of reversal was passed by the learned lower appellate court. My lord, the judgment
64 years during the year 2025 at the time of his death.
yes.
He expired on
My lord, he expired on my lord 14th April 2025.
14th April 2025. 65 years.
65 years.
Achha.
Now, my lord, I have taken that, my lord, kindly comes to page 10. Now, my lord, he was all along, my lord, suffering from
Paragraph
ailments.
10.
Paragraph 10.
Hmm.
But he was suffering from ailments.
Please,
Now, my lord,
please.
your petitioner states that since he is an age-dealing person who is almost bedridden, suffering from several comorbidities, and has to travel with aid, his health condition did not permit him to approach this honorable court and take steps to file this instant appeal before this honorable court within time.
When the judgment has been passed by the first
My
appellate
lord,
court,
first appellate court, my lord, the learned Munsif passed the judgment on 30th September 2015 and decree was drawn up on 17th November 2015. The
first appellate court,
my lord,
judgment has been passed on
22nd December
22nd
2021 and 9th February 2022.
COVID from March 2021.
March
March
2020.
2020.
March 2020.
Now, my lord, there was the second round of that, my lord, pandemic, my lord, which commenced in 2021, and that was, my lord, roughly in the month of, my lord, June and July. Now, my lord, this person, my lord, he was suffering from comorbidities. My lord, there was a chance that he could get infected by the COVID-19. Family members did not allow. The second round was, my lord, his advocate, my lord, with whom he had entrusted, lordship would get that at paragraph 11, but he had entrusted the file to one Nirjhor Kanti Mundul. Now, my lord, that learned advocate died. And my lord, the entire file of this appellant, my lord, was with his learned advocate. Now, my lord, on several occasions, my lord, he went to the chamber, the file could not be traced out. So, my lord, it took some time for the documents to be traced out.
When it is mentioned?
My lord, paragraph 11.
Paragraph 11.
Yes.
No, about the death of the learned advocate.
My lord, in paragraph 11, kindly comes to your petitioner says that after the COVID-19 pandemic had lost its lethality and normal life had resumed, the petitioner herein in the month of April 2022 went to the chamber of his learned advocate Sri Nirjhor Kanti Mondol with regard to taking steps of filing of the appeal when he was shocked and surprised to find that his learned advocate had died in the meanwhile. In such circumstances, the petitioner herein requested the family members of the learned advocate to trace out his file when he was told to come sometime in the month of June 2022. Your petitioner states that thereafter on several occasions on and from the month of June 2022 to October 2023, he with the aid of his son went to the chamber of the learned advocate but was unable to trace out the file, which also resulted in delay in filing of this instant appeal. Your petitioner says that he had no knowledge of the fact that the opposite party in the meantime had filed title execution case number 6 of 2023 in connection with title suit number such and such before the learned executing court, inter alia praying for execution of the decree as against the petition, and in connection thereto he had also filed an MC number 32 of 2023 before the learned executing court below, inter alia praying for providing necessary police help and assistance.
Miscellaneous case.
Yes. But in the last week of November 2023, we came to know from the police authorities that the opposite party has filed an application for police assistance. Now, thereafter,
you have obtained possession?
No. Now, thereafter, we could not trace out that file. We applied for the certified copy. But kindly comes to paragraph 15. But after obtaining the certified copy, we have filed this appeal. But we applied for the certified copy on 6 December 2023 and we, my lord, got it in our hand on 6th of February 2024. And thereafter on 15th of February 2024, we have filed the appeal. And not one more point. There was a direction, my lord, in their opposition to my application, but there was a direction by my lord Justice Rajabashu Choudhury, my lord, to my lordship would kindly, my lord, come to the order, my lord, dated my lord, 19th February 2025. Now, my lord, in my section 5 application,
19th February
2025, Lordship would get an order passed by my Lord Justice Raja Basu Chaudhary. Now, my lord, there was a direction, my lord, that in my application for condonation of delay, though I had stated that I was bedridden, I had not annexed my medical treatment documents. One. And my lord, secondly is, my lord, about the date of death of my learned advocate.
to properly explain the delay, this court grants leave to the petitioner to file supplementary
Lordship.
affidavit.
But I have filed a supplementary affidavit, and in that supplementary affidavit, my lord, I have annexed my medical treatment documents.
Acha, supplementary affidavit. Can do. Where are the documents?
My lord, Lordship would get it at the end. My lord, it starts from page 6, 7 onwards. Annexure S1.
Page 6.
Page 6. My lord, dizziness, tendency to fall. His blood pressure is 240 by 140. He was not a stable person.
Have you provided the death certificate?
No, my lord, death certificate is with my substitution application, Calcutta 3. My lord, he died thereafter. And my lord, along with it, my lord, I have stated, my lord, kindly takes up, my lord, point number, my lord, paragraph number.
Lordship, kindly consider my affidavit in reply to the supplementary affidavit, Your Lordship. That kindly see, Your Lordship, that paragraph number 7, Your Lordship. Reply to the supplementary affidavit, Your Lordship, paragraph number 7. Lordship, 9 February 2022, the date of decree passed by the learned First Appellate Court in TA Appeal number 4 of 2016. Now, April 2022 to October 2023, there is a no explanation, Your Lordship, provided for not filing the second appeal other than the face of demise of learned advocate representing the appellant before the trial court and first appellate court.
Isn't that
Yes, Lordship.
Sufficient?
Lordship, may explain, Lordship. Kindly see, Lordship, that April 2023 and the name of the advocate, which was mentioned by my senior learned friend, Lordship. But kindly see, Lordship,
Kanti
Mondol. But Lordship, kindly see page number 82 of the second stay application, Lordship. Kindly see, Lordship.
Something.
No, my lord.
Something wrong submission, Your Lordship. That
Kumar
Ajit Kumar বিশ্বাস appeared on behalf of the respondent in the first appellate court, Your Lordship, not Nijjhar, Your Lordship.
But I have stated that in my reply. But I have given the clarification.
Now, Lordship, kindly see page number 6, 4 of this.
Let him clarify.
Yes.
This point.
My lord, kindly comes to, my lord, internal page 7, paragraph
In the
8. Reply.
Internal page.
My lord, 7, paragraph number 8. Lordship would take up paragraph number, my lord, page 8. My lord, paragraph 7 starts from page 7 and continues till page 8.
Reply to supplementary affidavit.
My lord, this is the reply.
Reply to the affidavit in opposition of the section 5 application.
Section 5 application.
After considering the opposition and reply, Honorable Judge Justice Rajabashudi passed this order.
Yes.
Your Lordship.
Lordship is getting my affidavit in reply to the affidavit in opposition. That is affirmed on 11 June 2024.
As if the appeal is being heard. যেতে হবে যেতে হবে নিলে হবে না
But kindly takes up
paragraph
paragraph 9, internal page 8. In this context, my lord, some are 4 lines from the top. In this context, I say that Mr. Ajit Kumar বিশ্বাস, learned advocate, happens to be the chamber junior of Mr. Nirjor Kanti Mondal, learned advocate, was my learned advocate on record. But the entire file containing my case records were lying in the chamber of Nirjor Kanti Mondal. So, my lord, Ajit বিশ্বাস was the chamber junior of Nirjor Kanti. The file was in the chamber of Mr. Nirjor Kanti Mondal, and Mr. Nirjor Kanti Mondal had expired. So, but if I had to take the file, I had to take the file.
Mondal was a senior counsel.
Yes. But he was my counsel, and on record was merely Mr. Ajit Kumar বিশ্বাস.
Now, next point, Your Lordship, kindly see by reply to the supplementary affidavit, Your Lordship, page number 4, paragraph number 7, first 2 point, Your Lordship, I have explained. Paragraph number, page number 4, Your Lordship, that from October 2020.
Let me once again find out the
আমাদের রিপ্লাই আসছে না, আর কিচ্ছু দেখাচ্ছে যা লিখেছি তাই বলছি, বাইরে কোনো হাতে বন্ধ রাখি এই তো প্যারাগ্রাফ নাম্বার 7 জাস্ট আমাদের
ঠিক নেই মধ্যে কোনো কি ভুলে গেছে
affidavit. Paragraph number 7, Your Lordship. First,
number 7
7.
yes
Yes, Lordship, first date I have explained, Your Lordship, that 9 February 2022, the date of decree of the appellate court. Now, April 2022, October 2023, there is no explanation. Now, October 2023 to December 2020, no explanation for not obtaining the certified copy. 27th April 2020, date of filing of the title execution case, Your Lordship. And it did mention, Your Lordship. 1st September 2023, Nazir was directed by the learned trial court to execute the decree upon breaking of padlock, and 22nd 11/2023 was fixed for filing of execution report. Now, 22nd 11/2023, learned trial passed an order directing fresh step with regard to execution upon perusing the execution report, which noted that the decree could not be executed. 7th December 2023, date of filing of miscellaneous case being MC number.
Why the degree could not be executed? Because of
Order is annexed. Your Lordship, kindly see
resistance.
On yes, execution report has been received after not page number 10, Your Lordship. First order, Your Lordship, page number 9, and next page number 10, Your Lordship. 9 and 10, Your Lordship. Today is fixed for.
Yes.
Your Lordship.
Proceeded not and after not executed as per the report of the Nazir. No reason has been mentioned.
Yes, Your Lordship, and kindly see page number 9, that the petitioner, the order dated 1st September 2023, the petitioner Ramraja stated that on 30th September 2015 in regards to title appeal number such and such, who has directed the judgment debtor Nandulal Kurmi to deliver vacant possession of
You're-
Schedule B. So there,
You're placing which
page 9, Your Lordship,
the page 9, yes.
that the order dated 1st September 2023, there's a first, second, third, fourth, fifth paragraph, Your Lordship. The petitioner Ramraj Das stated that on 30th September 2015, in regards to title appeal number 4 of 2016, learned additional details such and such has directed the judgment debtor Nandulal Kurmi to deliver vacant possession of Schedule B property to the decree holder. However, the judgment debtor did not do the same. The decree holder therefore prayed for breaking the padlock and said house and said property and decree can be executed. So their knowledge, eventually, the date of eventual knowledge of the execution case, eventually, that the 1st September 2023, the report was served upon the decree hold the judgment debtor, eventually, but they have not taken any step, eventually, and there is a sufficient cause is. Lordship, I am to place eventually one judgment of the Honorable High Court Division Bench, eventually, that the delay is not a factor, but the sufficient cause should be explained, eventually. There is a division bench judgment presided by Lordship Shobhiraji Bhattacharya. So there is no explanation, eventually, Lordship. There is a sufficient cause, eventually. Lordship, paragraph 38 of the judgment, eventually, Lordship. As extracted from the judgment cited by both parties, the consistent view of the Supreme Court has been that although leniency is to be shown in favor of litigants in respect of continuation of delay, such lenience can only be exercised in favor of vigilant litigants. In such and such the Supreme Court held that rules of limitation are meant to ensure that parties do not resort to dilatory tactics. Even in the said case cited by the appellant, it was held that if the explanation does not smack of malafide or is not put forth as part of the dilatory strategy, the court must show utmost consideration to the shooter. However, whenever there is a reasonable ground to think that the delay was occasioned deliberately to gain time, the court should lean against acceptance of the explanation. And now, Lordship, paragraph 46, 44, eventually, Lordship. 42, sorry. Oh, 42, eventually, Lordship. In Prajapati Subba Reddy, upon considering its previous decision, the Supreme Court laid down the law on condonation of delay, paragraph 26, the said judgment quoted herein below. On a harmonious consideration of the provisions of the law as aforesaid and the law laid down by the court, it is evident that law of limitation is based on public policy that there should be an end to litigation by forfeiting the right of the remedy rather than the right itself. A right or the remedy that has not been exercised or availed of for a long time must come to an end or cease to exist after fixed period of time.
Is there any learned counsel that expired herein?
No. But eventually, Lordship, that there is no explanation, eventually, Lordship, that the learned counsel, that the Ajit Kumar Bishwas is appearing for that, but only after the knowledge of the
It has been stated that the name of the learned counsel whose name is appearing in the Wakalatnama is the advocate on record.
Yes.
But he is not the arguing counsel.
But Lordship, there is no bar eventually for applying for the certified copy of the order. But there is explanation eventually, Lordship, that due to date of the learned lawyer, they could not file for application for obtaining the certified copy. This is not a ground eventually, Lordship, for the delay. This is not a reason, Lordship. It's not a right reason. I'm only.
Anything more?
No, Lordship. But no explanation, I think so, Lordship.
Can
2 of 2024.
Can 2 of 2024 is taken up for hearing. the said application, the appellants have sought for condoning delay in filing the present appeal. Condoning delay of how many days?
642 days.
640 days. Condoning delay of 642 days in filing the present appeal. Full stop. Paragraph. Heard the learned counsels representing the appellants tenants, respondent landlord. The learned paragraph. Learned counsel representing the appellants tenants, substitute tenants, has submitted that the delay in filing the present appeal took place because of the death of the learned senior counsel representing the original tenant, before the first appellate court, namely
Nirjhor Kanti Mondol.
Mr. Nirjhor Kanti Mondol. Full stop. He has further submitted that the advocate on record was Mr.
Ajit Kumar Bishwas.
Ajit Kumar Bishwas and Mr. Mondol.
Nirjhor Kanti.
Mr. Mondol was the senior counsel who was the arguing counsel. He has further submitted that the said senior counsel has expired during
During the COVID times, but we do not know the date of his death. 2023 he expired.
Which part?
But we do not know the date.
During the year 2023. Full stop. And the said record was lying with him as he was the arguing counsel and not with the learned Mr.
Ajit Kumar Bishwas.
Mr. Bishwas. Full stop. Paragraph. The learned counsel representing the respondent landlord submits, opposes the prayer seeking condonation of delay and submits that there is no sufficient cause shown by the appellants.
Lordship, the learned advocate died in the year 2022.
2022.
Before 2022.
তাহলে ওই যে 2023 বলেছি না 22 লাস্ট কি হলো লাস্ট সেন্টেন্সটা
That also represented the landlord opposite the mayor seeking compensation for delay and submit that the application was shown by the appellants.
there is no sufficient cause shown by the appellants, but from whereby the condonation sought for can be allowed. Full stop. In support of his contention, the learned counsel has relied upon a judgment of the division bench of this honorable court, published in 2024, SCC online. In the case between BAXTER Baxter within bracket India Private Limited versus Debjani Bose, and published in 2024 SCC online Calcutta, page 11219. 11219 and has relied upon paragraphs number 38 and 42 of the said judgment. Full stop. Paragraph. On going through the record, it transpires that the coordinate bench of this court, by an earlier order dated
19th February 2025.
19th February 2025, had given an opportunity to the appellants to furnish sufficient cause as regards to condonation of delay, and to that effect, the appellants have furnished a supplementary affidavit, and in support of the said contention, some medical documents have been referred to. Full stop. Paragraph. It also transpires from the application that one Mr.
Kanti Mondol.
Kanti Mondol was the senior counsel who was the arguing counsel on behalf of the original tenant, and Mr.
Ajit Kumar Bishwas.
Ajit Kumar Bishwas was the advocate on record representing the tenant. Full stop. It also transpires that the said learned senior counsel, namely Mr. Mondol, has expired during the year 2022. If there's any wrong, rectify it. During the year 2022, and for that reason, and the record of the brief of the appellant original tenant was lying with the learned senior counsel who was arguing on his behalf, and not with the advocate on record. And as the learned senior counsel had expired during the meantime, so the appellant original tenant had to request the family members of the learned senior counsel to provide him with the file. Full stop. This entire episode took some time, which is the main contention of delay. Full stop. Though the judgment cited by the learned counsel representing the respondent cannot be kept aside or ignored, but in this instant list, there has been there has been death of the learned senior counsel who was representing the appellant original tenant. Full stop. So the circumstance wherein the judgment cited is not pari materia with the circumstance of this present list. Full stop. Considering the aforesaid facts and circumstances, the judgment cited by the learned counsel representing the respondent landlord cannot be taken into consideration in this present list. Full stop. From the paragraph, from the cause shown by the appellant tenants, it transpires that the said cause is sufficient. As such, the delay in filing the present appeal is condoned. Full stop. এবার তবে যে can
But can one is my application.
this one is can 2. Can 2 is allowed. Full stop. Now can
1 of
Can
2024 is my application for stay.
application for stay.
My
First of all, it be
Only thing is, my lord, their prayer for police help is allowed. But let my learned friend say that they will, my lord, not execute the decree, or otherwise, my lord, appeal is infructuous. I will again have to, my lord, come back for restoration of my possession if I am dispossessed. A limited period, my lord. In the meantime, I'll take steps to get my appeal admitted under order 41. My lord, a limited period. Otherwise, my lord, there was a.
stay cannot.
My lord, let my learned friend say that he will not execute the decree for a limited.
Stay cannot be, stay won't be. But learned counsel still, that is up to you.
My lord, there was a
I
similar
have no
observation
instructed
by my lord Justice Bivas Ranjan they also that don't proceed.
Yes, Your Worship.
Mr. Chakraborty,
I have no instructions.
to have the instruction. So, what to be done?
I does not record that.
Well, otherwise, my lord, the learned, it will be difficult for us to convince the executing court. They will say that nothing is there in this honorable court's order. My lord, I will say for a limited period, let them not proceed.
My lord, the leave of my senior, but earlier when Justice when Justice they had verbally observed, there might be some interim. It may not proceed.
No order of stay is being passed. But
My lord,
this is the general trend, learned counsel.
Yes, yes.
Or whether
Right.
the learned counsel representing the respondent landlord, agrees to the fact that till the admission of the instant appeal, present appeal, the landlord respondent shall not take any coercive step against the tenants appellants.
But kindly even limited the period, Your Worship. Otherwise, they have
No.
will not even move.
Till the admission. Till the admission.
Till the admission, I mean, next week, or in connection with title execution 6 of 2023.
But in this circumstance, you will be in advantageous position.
But
Yes, Your Worship.
limits it
But
for a
they have
period
not-
of limits it for a period of 1 month.
Finally, period limited.
Because there are many holidays intervening, but limits it for a period of 1 month.
Till 20th of February.
My lord,
Grateful.
with the leave again with the leave of my senior, I earlier also when Justice they had verbally observed, I had communicated the order and requested the learned advocate not to proceed. But my lord, the appellants did not take any steps for hearing of the stay application or the limitation.
No. The limitation application was running before my lord
It was
Justice
mentioned
Bivas.
last month. Last month was mentioned upon notice. Only
Only, at this stage, paragraph, at this stage, the learned counsel representing the appellants tenants submits that he will take immediate steps to have the application as regards to have the in present appeal admitted before the appropriate bench. Full stop. Full stop. In such circumstance, on the assurance of both the sides, let there not be any coercive step taken by the respondent landlord till 28th of February.
Grateful. Take it. But absolutely balanced.
And in the meantime, the learned counsel representing the appellants, tenants, is requested to take appropriate steps.
Grateful.
Item number 21, I prefer not to demand. 21, next.
Learned counsel, when the matter will be called, be kind enough to be present.
I am opposing.
My lord, 21, my lord, I prefer only not to demand.
It will be taken up at 2 p.m.
My lord, learned advocate for this petition, appellant, my lord.
Learned counsel,
Duty illness, he has not come today, my lord. I prefer only not to demand.
the matter will be taken up at 2 p.m.
My lord, 2 p.m., my lord, I
There is a photo session at 1:30. That's why the court will have to rise.
My lord, maybe this, my lord.
It will be called at 2 p.m.
No, I prefer only not to demand, my lord.
একবার সবসময় বলছেন তুই আসুন না
Other 21 I paper not today.
October matter টাকা
अरे दिल्ली में हमारा पानी not today. Item number 2, pass over matter. By the transfer is a bit. 100 to 100. Pass over matter. Pass over. Send a WhatsApp message also.
in presence of both sides. In presence of both sides, the matter was fixed for today. Fight order dated 19th of December 2025. Though the appellant is being represented, but none is representing the respondents. Mr. Taroknath Haldar representing the respondents. No accommodation has been sought for. For the ends of justice, let the matter be kept on 9th of January 2026 at the top of the list. 9th of January 2026 at the top of the list. The learned counsel representing the appellant is requested to inform the learned counsel representing the respondents and to file an affidavit to that effect on the next date.
It is very similar to other sense.
I will
From the address of business.
as regards to the next date of hearing.
2 p.m. or 10:30?
No, 10:30 at the top. At the top. Top থাকবে under the heading hearing. Under the heading hearing. Automatically it will be at the top because one has been completed.
Great.
এইটা কিন্তু এক নম্বর আইটেম থাকবে next rate. Okay.
Pass over matter. Item number serial 3.
নিমতো একটা অর্ডার নিমতো in the order dated 28/11/2025 the name of the learned counsel representing the appellants has been wrongly typed as HON'BLE.
Is there a junior?
আচ্ছা
His name is also so.
ঠিক আছে থাক কিছু দরকার নেই I thought that then we can start.
Yes.
ওটা কিছু দরকার নেই ওটা paper book. This one is the paper book.
Yes, this is the paper.
But I cannot say whether it will take 1.5 hours or not. For the first day, let us take up this matter. How can Leonard Senior Counsel? Yes.
Millard, a judgment of affirmance. Millard, my suit was dismissed. Thereafter, Millard appeal preferred. Millard appeal court has also dismissed my appeal. This is the judgment of affirmance. Now, Millard, kindly see, Millard, the order dated, Millard, the 5th of October 2018, passed by the Honorable Bench. Millard, what are the substantial questions of law? 5th October 2018.
Paper book page
44.
1, 2, 3, and 4.
Yes, these are the Millard substantial questions of law, Millard, which were framed, Millard, while admitting the appeal.
The deed is sale or
Sell deed.
Sell deed.
Sell.
Was executed only a day prior to his
Prior
death.
to that, prior to his death.
Certificate issued by the doctor. This appropriate cerebral letter and yes.
Millard, kindly see, Millard, what are the Millard judgments, Millard, passed. Let us see, Millard, the trial court's judgment, Millard, passed 31st March 2011.
Yes.
Kindly see, Millard, the second page, the plaint case, the plaint case in a nutshell is that the suit property under CS Khotiar number 216 was recorded in the name of one Brojomohan Ala. After his demise, Haran Chandra Ala and Palan Chandra Ala, his sons, inherited the same. The plaintiffs are the legal heirs of Palan, and they were in joint possession of the suit property with the said Haran. During revisional settlement, the plaintiffs were minors and Haran got the suit property record in his name. The entries herein were erroneous. The plaintiffs also alleged that Haran did not have 16 ana share in the suit property and he did not have the capacity to transfer the whole of it. The plaintiff further averred in the plaint that the property under Onja Baura under Khotiar number 98 was recorded in the name of Shupatiwala Dashi and Haran Chandra Ala having 8 ana share each, and the same was recorded accordingly in their names in the arrest record. The present plaintiffs are the sons of Shupatiwala Dashi. It has been alleged by the plaintiff that they and the state Haran Chandra Ala got the suit property under Khotiar number 235 and 399 in terms of the Cholenama decree passed in title suit number such and such, and got 28 decimals of land in plot number 371 under Khotiar suit Khotiar number 283 by a separate degree passed by the court of the learned court of the then learned first Munsif in title suit number 230 of 1981. They further alleged that the said Haran Ala could not execute any deed in favor of the defendant as because the said appeals were pending at that point of time. it was their contention that the suit property under LR Khotiar number 605 and 598 belonged to them. The plaintiffs further contended that Haran Chandra Ala was a bachelor and he became unconscious following the heart disease on 28 August 1998. Therefore, Milord, the court case proceeds that Haran Chandra Ala was a bachelor and he became unconscious following heart disease on 28 August 1998, and that he died on 1st of September 1998. It was awarded by them that after his demise, they inherited the property of Haran. It was further alleged by them that Haran did not accept rupees 40,000 from the defendants, and that the defendants had no capacity to pay the said sum.
The impugned deed has been executed on 31st day of August, 1998.
Their house.
Yes, 1990, yes. Just before 1 day before the death, yes.
31st. One minute. Mr. Haldar, where were you? So the matter will be taken up. It will be taken up after completion of this one. ওই অর্ডারটা এখন দরকার নেই ওটা Mr. Haldar, at least one should have been there to represent you. Where is he? ওই অর্ডারটা টাইপ করবেন
May I once see the LCR Milord, one portion.
একটু ওই ট্রায়াল কোড রেকর্ড এবং ফার্স্ট অ্যাপলেট কোড রেকর্ড দিন
May I proceed?
Yes.
It was alleged by them that Haran did not accept rupees 40,000 rupees from the defendant, and that the defendant had no capacity to pay the said sum. It was also alleged by the plaintiff that Haran Chandra Ala was unconscious at the time of alleged said deed. It was their allegation that the defendants had manufactured the said deed in their favor. There was absence of free will and free consent on the part of Haran, they allege. The plaintiffs have alleged that the defendants have no right, title, and interest in the suit property, but they are trying to disturb the peaceful possession in the suit property, hence the suit. The defendants appeared to contest the suit. They denied all such allegations by filing written statement. The defendants alleged that that the suit was not maintainable, and the plaintiffs have no cause of action of the said suit. The defendants denied each and every allegation being set out in the plaint. The defendant specifically averts in the written statement that they have purchased the suit property under plot number 2445, 446, and the 2473, along with other non-suit property for a consideration of rupees 40,000 by a registered deed of conveyance on 31st August 1998, which is the deed. And from the very date they were in possession of same, doing various acts of possession. They further avert that the plaintiffs were not the legal.
So the moot point is whether at the time of execution of the impugned deed, this Mr. Haran Chandra Ala was capable or not.
That is the point.
Mentally
Yes.
capable or not. This is the moot point.
Mental and physical capacity.
Physically, hopefully he was, may or may not be, but mentally, as a cerebral attack. Let us confine ourselves within this point only.
Yes. The judgment revolves only on that only. Then, Milord, issues were framed. Then, Milord, kindly see, Milord, page 5. Decision with reasons. 1, 2, and 7, Milord, they were it was held that it was not barred under section 34, and it was decided in favor of the plaintiffs. Nothing much to say. Kindly see issue 3 and 4. Both the issues are taken up for brevity and discussion and to avoid repetition. It is the case of the defendant that they had purchased the suit property from Haran Chandra Allah since this is for consideration of rupees 40,000. They have also averred that the said Haran Chandra Allah was free to execute the said sale deed. The contention of the plaintiff that Haran Chandra Allah was not free as he suffered from heart attack and that he fell unconscious. It was their further allegation that there was no free will or free consent on the part of Haran to execute the impugn deed in favor of the defendant, and that Haran did not have any mental or physical capacity of the same. Their allegation was that the defendants manufactured the said deed in conjunction with the sub-register. Now let us consider the evidence on record and the argument thereof.
It took place on commission at the house of Haran Chandra Allah.
Lord, that is also, my lord, now as I proceed with the evidences on record, my lord, that is also doubtful. That will be also doubtful.
So entirety is
it appears from the deed itself. Deed itself, but doubtful. The PW1 filed the medical certificate of Haran Chandra Allah issued by one Dr. S.K. Banerjee. He also filed the death certificate of Haran Allah.
No application is pending.
No.
Why it is still no SAT?
Department has to give a number.
যেগুলো আর কিছু পেন্ডিং থাকবে না বুঝেছেন সেগুলোকে সেকেন্ড অ্যাপিল টেন্ডার থেকে টেন্ডারটা সরিয়ে দিয়ে এসে সেকেন্ড অ্যাপিলে সরিয়ে দেবেন it should be automatic.
Process is, my lord, as soon as it is admitted, has to department has to give it.
এটা পাঠিয়ে দেবেন বুঝেছেন যদি কোনো order করতে হবে is order required order I think at this stage I think order is required ঠিক আছে তাহলে যখন অর্ডারটা হবে না লাস্টে
PW1 filed the medical certificate of Haran Allah issued by one Dr. S.K. Banerjee. He also filed the death certificate of Haran Allah. PW2 stated in his examination in chief that he knew that Haran Chandra Allah and the parties to the suit. He stated that Haran Chandra Allah died more than 10 years ago. He fell down at a place called Chinair Mott, remained unconscious for 4 days and died of heart disease. And the date of death is 31st August 1998. During his cross-examination, he stated that he had no idea as to whether Haran Allah suffered a heart attack or not. He further stated that he was not admitted in any hospital or nursing home. PW3 stated that in his examination in chief that he knew Haran Allah and he heard that Haran died of heart disease on the date must be missing. He also stated that Haran died on 1st of September 1998. He also stated that Haran sold a piece of land to him and an amount was due to Haran and that he went to pay the same to Haran. He further stated that Shubal Chandra Allah PW1 informed him that Haran Allah had died. Later, he went to the house of defendant number 1 and learned that he was unconscious. During his cross-examination, the PW3 stated that he did not know the date of death of his father. The PW4 stated in his cross-examination examination in chief that he knew Dr. S.K. Banerjee, who was a registered medical practitioner. He also knew Haran Chandra Allah
who died of cerebral attack. PW4 Millard is the compounder of the advocate. The cerebral, he identified the handwriting of Dr. Banerjee and the medical certificate.
Yes, he did everything. He did everything. In his cross-examination, the PW4,
He identified the handwriting of the.
he did everything.
Yes. No. Thereafter, Millard, there is some.
In his cross-examination.
Yes. His contention was that Haran Chandra Ala died after 3-4 days of suffering cerebral attack, and during that period he was unconscious. In his cross-examination, PW1 stated he did not know the stated that he did not know the full name of Dr. S.K. Banerjee. He considered to the fact
Under
that
whom he was the compounder.
he was the compounder, and this Millard weighed heavily with the learned trial judge as well as the learned first appellate court, Millard, to disbelieve Millard the evidence of PW. For this Millard, one line of the Millard. Yes,
he considered to
the fact that he had no idea about medical treatment and diagnosis of the disease. It was the suggestion of the defendant that said Dr. S.K. Banerjee was not a doctor, and the PW4 did not assist him. The DW1 stated in support of his case in his examination in chief on affidavit. In his cross examination, he stated that Haran Ala was a literate person. He failed to say as to whether Haran Ala died of cerebral thrombosis or not. He denied that he did not pay the consideration money of the impugned deed, and he got the deed executed by an unconscious Haran Ala, and he did not possess the suit property.
Whether the witnesses have been examined herein, they are witnesses to the impugned deed.
If your lordship kind enough to ছিল সমর বিশ্বাস and স্বপন মন্ডল, yes.
They are
সমর নস্কর is DW2.
Omor Noskor is DW2.
One of the attesting witness. Swapon Noskor DW3 is another attesting witness.
So these two, DW2 and DW3.
Now, Millard, here, Millard, kindly lordship has seen what he has said. Did Millard,
apart from these two persons, is there any other
DW4?
Bablu Gayan, DW4. He is also a distinct witness.
I'm finding it out. Then Millard, kindly see Millard, this paragraph. What was the Millard cross-examination of DW1? Millard, DW1, Millard says that in his cross-examination, he stated Haran Ala was a literate person. He failed to say as to whether Haran Ala died on cerebral thrombosis or not. He denied he did not pay the consideration money for the impugned deed, and he got the said deed executed by unconscious Haran Ala, and he did not possess the suit property.
Can we confine ourselves to the evidence of the attesting witnesses and the medical documents?
Yes, that is there.
I think that will.
The next two pages is only Millard discussion of DW3 and DW2 and 3 only.
Better to go through from the
original one. Yes.
One.
And as soon as I
rather than rather than from the
as I complete,
judgment.
I'll hand over the
Because from the judgment, it can be picked from here, from there also.
definitely, definitely. Well, at here, Milord, my point would be, Milord, if he was Milord, a literate person, Haranala, then Milord, there was no justification, Milord, in doing Milord, holding Milord the deed on commission and by putting Milord thumb impression.
As regards to thumb impression, you can say. On commission, as regards to literacy,
exactly. I'm coming to that. I'm coming to that. Yes. Kindly see, Milord. This was Milord exhibited, Milord, at the instance of the defendants. This is exhibit B.
both of you have gone through the documents. All the documents are
That's
there.
why, Milord, I want. I
All the
ask him
documents
to.
are there.
Yeah, I have not seen it.
No. Why didn't you?
I didn't.
It is the request from this end to each and every learned counsel to go through the original documents prior to hearing.
The original deed also was submitted. Yes, it's kept in a
Tin box.
ওটা withdraw করে নিয়েছেন আপনারা সার্টিফাইড কপি রয়েছে অন আন্ডারটেকিং আপনারা kindly see, Milord, the second page. That's the stamp page, Milord.
Acha.
The first page, Milord, and the page 97.
Page 97. Acha, 97. Yes, 97.
Kindly see, Milord, in whose name, Milord, the stamp paper was purchased. Kindly see. The stamp.
Haradhan,
Exactly. Exactly. Haradhan Ala and not Haran Chandra Ala. Then, Milord, kindly see the who is the Milord Kovala Data. Next page.
Address of Haran, whatever maybe Haran, Haradhan
Ala or Haran Chandra Ala.
Haran Chandra Ala. Address is South Korea. South Korea. Acha, son of late Brojo Mohan Ala.
Yes, Brojo Mohan Ala.
Because the father's name, it is correct.
Because at that point of time, admittedly, Milord, Mr. Ala, Milord was not in Milord's senses. He had no Milord capacity to Milord to go and purchase. That's why it was Milord, the purchaser was one Shomor Bishwas.
Shomor Bishwas, the son of Kishori Bishwas.
Exactly. And Shomor Bishwas is also Bokolom, Milord. Then, Milord, kindly see the name who is Milord Kovala Data in the deed. The next page.
Kovala Rohita is Shirish Rohita.
So they are the defendants. They are the defendants. Or not that page, Milord, that page after 97.
Kovala Data is Haradhan.
Exactly.
Haradhan Ala.
Exactly.
Not Haran Chandra Ala.
No. Now, Milord, the next Milord thing, Milord, which I will be. Let me complete the judgment and.
Only the documents and the evidence of the practicing witnesses.
Findings of the court, Milord. That's the.
Acha, thereafter, findings of the court. This will give the
clear picture.
Haradhan Ala. The original name is Haran Chandra Ala. Yes.
Now, Milord, the next document, Milord, let me, Milord, show you to.
Required. Was this point raised before the trial court, first appellate court?
My lord, let me check it out. Yes. Now, my lord, kindly see, my lord, page 112 and 113. Kindly see, my lord, this is the, my lord, death certificate of Haran Chandrawala,
The earlier one was page number
97.
97. Now we come to
97, and my lord's mark is at page 98.
97, 98. Now we come to
Page
page number.
112 and
Let it
113.
be, let it be there. Let it be there.
When?
Page 100,
12,
12,
and continuation is 113.
112 and 130.
This is, my lord, exhibit E.
Mhm.
Exhibit E from the side of the defendants, which was marked on with objection. Now, my lord, kindly see, my lord.
No, let it be there. Let it be there.
Yes, here, my lord, kindly see. I am reading the first, my lord, line. The Ghoshpur Nivashi Sri Shubh. This is this certificate is being given by Rajpur Sonarpur Paurasabha Sabdaho Ghat. Ghoshpur Nivashi Sri Shubol Chandrawala. Chandrawala. Deed is Haradhanala. Now, my lord, the Nivashi Shubol Chandrawala is the plaintiff, not the son. My lord, here, my lord, he is my lord, taking, my lord, the certified copy of this. নিকট হইতে নিম্নে দ্রষ্টব্য সপ্তাহের জন্য 220 টাকা পাইয়া রসিদ দেওয়া হলো বিবরণ মৃত্যুর তারিখ 1/9/98 মৃতের নাম হারান চন্দ্রওয়ালা, not হারাধনালা. Here also, my lord, kindly see the name is father's name is Brojomohon Ala, বাসস্থান ঘোষপুর থানা বারুইপুর, মৃতের নাম ওই মৃতের কারণ.
So the name of the father remains same.
Same.
This certificate has been issued at the time of cremation.
Sabdaho Ghat.
Yes, cremation.
Yes, Sabdaho Ghater রসিদের নকল.
Therein Haradhanala.
Now, here is Haran Chandrawala.
Haran Chandrawala.
This is page 112 and 130. So, let us now, my lord, come, my lord, to the judgment, my lord, because the learned trial judge, both the courts have, my lord, said that consideration has been passed on, which is one of our main, my lord, point in this. Never consideration, never. I'll show from your lordship, my lord, two things. One, consideration was never passed on, and secondly, my lord, the health condition of Mr. Ala at that point of time. For that, my lord, kindly, my lord, let us continue from page 7 of the, my lord, DW2, evidence of DW2. Thereafter, I'll show the medical certificate and, my lord, the evidences. DW2, Shomon Noshkor, in his examination in chief, he and my lord has noted the fact, my lord, DW1 stated he was literate, but and he never knew that whether the Mr. Ala was suffering from, my lord, cerebral thrombosis or not, and that he denied that he had not paid consideration. This is the specific 3 cases of DW1. My lord has noted.
No, lord, he denied that he did not pay. Means he paid.
Paid. He paid. Therefore, my lord has seen, my lord, first, the stamp paper was not, my lord, at least it should have been in the correct name. Secondly, my lord, if the DW1's, my lord, cross-examination is correct, that he was literate, then there was no explanation why at that point of time he should be examined on commission. The deed was executed on commission, and that he had to put a thumb impression at the time of execution of the deed. These are the points. Then let us see DW2 what he says. Shamor Noshko stated in examination in chief that he knew Haran Allah for 17-18 years, and he cultivated his land previously. He contended that as per the dictates of Haran Allah, he went to the house of Mir Motiar Rahman, a law clerk, and took him to the house of Haran. Motiar prepared the draft and he showed it to Haran, and the deed impugned was prepared on the basis of the said draft. He stated further that Haran Allah was the owner of the said property and that he sold the same to the defendants while being in a fit state. He also stated that as the hands of Haran was trembling, he put his left thumb impression on the said deed in his presence. But DW1, who was also present there, who is the purchaser of the property, he does not throw any light on this. If the deed goes, he is the first person, it can be understood that the purchaser has no direct knowledge regarding his health, but he must come and say whether his hands are trembling, because he was present. He can see with his eyes what was the condition of health on apparent on that basis he could have said there is nothing. Who is the Mir Motiar Rahman? He was the draftsman, deed writer.
So according to you, DW2 intended to cover up.
He was more interested than DW1. Prepared draft and he showed it to Haran, and the deed impugned was prepared on the basis of the said draft. He stated further that Haran Allah was the owner of the suit property and he sold the same to the defendants while being in a fit state. He also stated that the hands of Haran was trembling, but his left thumb impression on the said deed trembling. He put his left thumb impression on the said deed in his presence. If he was fit, then there was no occasion to put the left thumb impression on the deed.
And being literate
and being literate. If he was fit, if he was unfit, his hands were trembling. Yes, sometimes we have seen even literate persons are putting it has a left thumb impression. It several times I have seen it happen in bank records also when signatures doesn't match happens. But this is the thing that he identified the LTI of
Haran Allah expired in his house.
In his house,
not in any hospital or.
Within 3 days, everything happened. He fell down unconscious, and just before 1 day before death, deed executed. Very good time. If Haran Allah had intended to sell the property, and if he had other dire necessity for money, he could have done it earlier also. Why on the last day of the 1 day before his death?
Because he knew the last day.
Yes. He identified the LTI of Haran Haradun Allah. His further contention was that the deed was registered on commission in the house of Haran Allah.
When that stamp paper was purchased, date? On the date of execution.
The date of execution. So hurriedly.
Only 100 rupees. 100 rupees.
Yes.
2000 rupees.
1,000 rupees. 1,000. Total 2,000. Total 2000.
2 pages
2 pages. Total 2000.
in the second page, backside of the second page, backside of the second page.
Probably, my lord, they have withdrawn, my lord, the original deed. That's why a certified copy.
That has been furnished. So you can
furnished.
tin box, tin box to tin box, tin box to.
হ্যাঁ ওইটা আন্ডারটেকিং দিয়ে এটা সার্টিফাইড কপি দিয়েছিলেন ওইটা ট্রায়াল কোর্ট। ট্রায়াল কোর্টেই তো বলছি, এখানে নয়। ও তালা খুলতে may I open this?
Yes.
No, no, don't tell me.
This one,
The second,
this one.
yes, this one. Stamp paper purchased by the purchaser.
The name of the purchaser.
In the second 1000 rupee stamp, back side. Not in the name of vendor.
Yes, Haradon Allah is being identified by Shongor Bisha. Haradon Allah. This is the original.
The stamped paper has been purchased in the name of Shirish Das.
Das.
Shirish Das.
Purchaser.
Is that thereafter? No. And others, I think so. And
Shirish Das.
ওই
Shang, South Korea. 2000 rupees.
South Korea. আর হারাধন
Identification is Shomor.
Identified by Shomor Bishwas. The executed by Haradhon Allah.
Haradhon Allah.
Yes. Purchased on 31st of August.
And I'll show Milord the evidence of DW1 where
this is the sole document, and apart from this, medical
is there.
The medical documents
here
certified copy. No, original.
Original copy is there.
Yes, ওখানে থাক তালা লাগাতে হবে না, পরে হিয়ারিং হয়ে যাক। Yes.
Then Milord, his father, he identified the LTI of Haradon Allah. His further contention was that the said deed was registered on commission in the house of Haran Allah. During his cross-examination, DW2 identified his signature in the said deed. He stated therein that Haran Allah called upon him and went to his house. The fact also came in the light that the deed was signed in his presence. He further stated in his cross-examination that Bablu Gain DW4 and Shopon Noskor DW3 put their signatures on the deed. The DW2 further the DW2 further stated in his cross-examination that the impugned deed was prepared in his presence by Moti Mohori, the law clerk, deed writer, and Sunil Das, the defendant number 2, gave the rest of amount of rupees 10,000 to Haran Allah. rest amount of, yes, of 10,000 to Haran Ala. He denied that the deed, said deed was he denied that the said deed was a collusive one. Therefore, Milord, on the first part of the Milord, the evidence, Milord, he says, Milord, that hands were trembling, and he identified the LTI of Haran Ala, and during cross-examination, he identified his signature, and he was called upon to visit the house of Haran Chandra Ala, where he signed in presence of the other attesting witness, and the Sunil Das, the defendant number 2, gave the rest 10,000 rupees to Haran Chandra Ala. He denied the said deed was a collusive one. Milord, I will be, Milord, showing the evidence, and Milord, arguing on this. I will say why only 10,000. The remaining portion of the consideration money was never passed on. I'll show to your lordship. The DW3 stated in his examination in chief that he knew Haran Ala, who sold the suit property to the defendant. He also stated that Haran Chandra Ala put his LTI on that said deed in his presence, and DW2 identified his LTI. He put his signature thereon as witness, and Somod Bishas, DW2, Romen Shoddar, Shapon Mondol, Bablu Gayan signed therein as witness in his presence. During his cross-examination, DW3 stated that Sunil Das, the defendant number 2, called him on the date of registration of the said deed, and the same was read over and explained to him. DW4 in the same line as the other witness, Milord DW4. Then, Milord, arguments, Milord, kindly comes to Milord page 9, the last paragraph. Learned advocate appearing on behalf of the plaintiff submitted. Last, my lord, appearing on behalf of the because submitted in his argument, the instant deed was executed under suspected atmosphere in paragraph. Since my learned senior friend wants me lot to, because your lordship wanted to only confine to this,
yes, because
when Subol name was expunged from the earlier suit.
Whatever may be, but we are to deal with only these documents, medical documents, and in addition, the evidence of the attesting witnesses. This will give the entire picture, clear picture.
That's why, Milord, I started from this paragraph.
The medical documents.
Very good.
Those have been marked. And where they have been dealt with.
Yes, that is, Milord, there.
No. The substantial question of law, that is number 2. If your lordship kindly turns to substantial question of law.
Whether the courts below are discarding
when the said medical certificate or exhibited without objection, this is not correct. With objection, it will be apparent. I'll show your lordship that with objection.
Now, Milord, this is, Milord, the page 66 is the page 66 of the, Milord, lower court. This is, Milord, the certificate issued by the doctor in favor of on account of death of Haran Chandra Ala. Page 66 is very important. This is exhibit.
So this is the death certificate issued by the doctor.
It says this is to certify that Sri Haran Chandra Ala of PO South Korea village Sajansal district 24 Parganas is under treatment from 28 August 1998 he is suffering from cerebral attack, unconscious with right side hemoplegia, for which he is to take complete rest in bed. For this case, he cannot be attend for this cause he cannot attend any place. My lord, initially, my lord, on their objection, this was marked X for identification. Thereafter, my lord, this was proved, and my lord, this was marked exhibit after objection.
Exhibit.
This is, my lord, exhibit number 15 after objection. Yes, my learned senior friend is absolutely correct. There is an incorrect recording in the substantial question of law number 2 marked without objection. My lord, that is perhaps an incorrect recording.
Exhibit 15 with objection.
With objection.
What's strange and surprising that the seal of the doctor normally.
You will get opportunity, ample opportunity.
Then, my lord, kindly see, my lord, that paragraph.
This is the sole document.
This is the only document, medical document. This is the only medical. Issued on 31st August 1998. Registration name.
And according to you, he fell 4 days prior to that.
Exactly.
4 or 3 days prior to
that. Exact dates, my lord.
28th.
28. Deed was executed on 31st August. He died on 1st September 1998, and he fell 3 days before that. 3.
And you are the
I'm the legal heir
of Haran.
Yes, we kindly see the
Elder brother.
Haran's elder brother. We IPO, my lord. Subal Chandra.
No.
Issueless. My lord, what happened, my lord? There were two property was originally of Brojomohan Ala. Brojomohan has two sons, Haran and Palan, 50-50.
On the death of Brojomohan, Haran Palan, 50-50.
Haran Palan, my lord, we are the son of Palan. Now, my lord, admitted case, Haran was unmarried and issueless, therefore the brother's son.
And apart from exhibit 15,
I could not find anything on the medical document on record.
Out of context, you did not treat your Jatamasai well.
Same one. My lord, the cremation was done by me.
That you have done.
Last done. Then my lord, learned advocate appearing on behalf of the submitted in his argument that the instant deed was executed under suspected atmosphere in favor of a person who was absolutely not related to Haranala. He submitted that there was no endorsement by the sub-register to the effect that rupees 10,000 was given in his presence. He argued that the document under Exhibit E revealed that Haranala died of prolonged illness. His argument the argument was that Haran Allah was a literate person, and he put his LTI on the said deed. It would be presumed that he had no strength at all to put his signature. He added that there was no endorsement in the deed that the same was registered on commission. it was further contended by him that evidence of the doctor was not of much value, since Haran Allah died died within 1 day of the execution of the deed. The execution of the deed. He contended inter alia that the death certificate did not show that he died of heart attack. His further submission was that the deed was not did not contain the fact that the defendant paid rupees 10,000 on the said date, and that they paid rupees 40,000 on previous occasion. He relied on a judgment of the Honorable Court as reported in such and such, and submitted that the burden of proving the genuineness of the instant deed was on the defendant, as they took advantage of the physical infirmity of Haran Allah and got the deed executed in his favor. In reply, the learned advocate of the defendant submitted that it was nobody's case that Haran Allah was illiterate. He added that there was no case that Haran was in coma at that point coma at a relevant point of time. Having considered rival contentions and evidence on record, this court finds that Haran Allah, the vendor, was suffering from illness at the relevant point of time. The plaintiffs have alleged that the deed impugned was executed under suspicious circumstances. It is for them to prove the said allegation. This court is of the view that the defendants had no burden on them to prove the genuineness of the said deed. It is the rule of evidence that the party alleging the existence or non-existence of certain things, the thing has to prove the same. There was no proof that the Haran Allah was under coma at the relevant point of time. There was no proof that the fact that Haran was incapacitated by such disease. The explanation by the defendants that the hand of Haran Allah was trembling by reason of his illness was a trustworthy one, especially when nothing was proved to the contrary. Court has, with deepest of respect, Milord confused himself. Milord, if Milord, there is, kindly see, there was no proof that Haran Allah was under a coma at relevant point of time. There was no proof of the fact that Haran was incapacitated by such disease. The explanation that the defendants in the say that the hand of Haran Allah was trembling by reason of illness was a trustworthy one. Milord, if the previous two lines, Milord, finding of in the previous two line is correct, then Milord, what I do not know whether how the learned trial judge is coming to finding in the next line that his hands were trembling, but there is no reason but that he was there is no evidence that he was ill, but his hands were trembling.
How could he have got to this conclusion that his hands were trembling?
Trembling. Then, Milord, next page. The evidence of PW4 was of no value since the court did not found him competent enough to prove the certificate issued by Dr. S.K. Banerjee. Reason being, he could not tell the full name of the doctor under which he claimed that he served as a compounder. Normally, Milord, court is Milord giving Milord his own Milord version, Milord own Milord knowledge of matters. Kindly see, normally it is expected that a compounder attached to a doctor would be well acquainted with his name. It is quite surprising that he was not aware of the full name of Dr. S.K. Banerjee. So the court was unable to come to the conclusion that Haran Allah has been suffering from such illness which completely incapacitated him from doing the day-to-day work, from understanding the very nature of his activities. Now, Milord, if your Lordship would once, Milord, kindly see, Milord, page 66 again. Page 66 again. Milord,
medical certificate.
The doctor himself is writing as S.K. Banerjee. Doctor himself is writing as S.K. Banerjee. S.K. Banerjee and his Milord.
On the top, there is no name prescribed.
Yes, Dr. S.K. Banerjee
at the left hand.
At the left hand side, and Milord, even his Milord the registration number is also given. Registration number is also given. and Milord, where he is attached, Milord, which hospital, everything is given. This was their raised objection, marked tentatively, Milord, as X for identification or Y for identification. X for identification. Then we called that compounder, Milord. He, Milord, identified, Milord, the handwriting. Yes, he could not say what is the, Milord, full name of Dr. S.K. Banerjee. But the Dr. S.K. Banerjee himself in his, Milord, letter, in his pad, Milord, is writing as Dr. S.K. Banerjee. Milord, full, Milord, registration number is given, where his chamber, timing, phone number, Milord, in which hospital he is attached. And Milord, kindly see, Milord, he is attached, Milord, very reputed hospitals. Milord, everything, Milord, kindly see. এটা রাখছি।
রামকৃষ্ণ সেবাশ্রম
সেবা প্রতিষ্ঠান, Milord.
সেবা প্রতিষ্ঠান
It's a Seva Ashram, yes.
সেবা প্রতিষ্ঠান is near Hajra Shishumoglu.
Not that. Anyway, but he was a registered practitioner.
লাগিয়ে দেবেন, ঠিক আছে, মনে করে নাহলে কিন্তু প্রবলেম হবে।
Milord, another thing, Milord, kindly see, Milord, the note given by the registrar that
on commission
red, yes, red mark. In the private residence of, kindly see the name.
Haran Chandra Ala.
No, no, not Chandra.
Aradhan Ala.
Exactly. Now, Milord, here, Milord, comes, Milord, my second point. Milord, if this finding of the trial court is correct, that there is no, Milord, proof of the fact that Haran Ala was incapacitated by such disease, Milord, then, Milord, comes, Milord, my second point. What was the, Milord, necessity, Milord, to get the deed registered on commission? He could have easily walked there. He could have easily gone there and get the deed registered. Exactly. Now, Milord, kindly see the last, Milord, after schedule, Milord, a note is given.
Receipt of money.
No.
Corrections.
Kindly see পূর্বে
corrections
পূর্বে সই করিতে পারতাম, বর্তমানে অসুস্থতায় জন্য টিপ সই করিলাম। Milord, correction, Milord, first of all, দলিল পাঠ করিয়া
explanation to the thumb impression.
Explanation to the thumb impression. Who is giving this explanation? Person, Milord, who, Milord, is writing, Milord, is putting, Milord, this thumb impression, Milord, he is saying as if I have personal, I used to sign earlier, but I cannot sign. Not the language should have been the vendor used to sign, but due to incapacity he could not. As if Milord, the language it is coming up, I do not know, because there is no endorsement of the registrar here. Whether this has been Milord put subsequently, Milord, that is also Milord has to be looked into. Kindly see Milord the line.
Take this one. Verify with the original one.
This is the original one.
No, verify with the original one. The certified copy has been filed. The detail. With the Italian.
No, that certified copy perhaps will not help, because that has been perhaps during after disposal of the suit, certified copy was obtained from the court and deposited. We will let me check up. It would have been checked up only if volume copy has been called for from the registry office. Yes, same thing. This kindly see the copying department of Civil Judge Junior Division, Barwipur Court, these certified copies were.
Yes. Next point.
Then kindly see the the next page,
The doctor.
Yes. In reply, the last paragraph I had already placed that evidence of PW4 is of no value. The compounder. Since the court, since the court did not
he could not say the
who was the name, but he proved the handwriting. He said that this is the prescription, the pad, letterhead, and the handwriting, but he could not say that court has taken the adverse inference that normally a compounder cannot, who is working with Dr. S.K. Banerjee, he cannot say the name of Dr. S.K. Banerjee, that therefore the evidence of DW4 is not worthy of believing. That is the finding. Then next paragraph, the evidence of DW2 and DW3 and DW4 could not be shaken in cross-examination. Rather, the fact is established beyond doubt that Haran Allah executed the impugned deed in their presence, and the plaintiff could not outweigh their version by adducing any cogent evidence on record. The impugned deed was registered on commission in the house of Haran Allah. This is admitted. We can see from that there was endorsement on the effect of in the said deed. The allegation that the defendant manufactured the said deed in collusion with sub-registrar was devoid of any merit. It is the general presumption that any public officer has done his duty as is required by law for the time being in force. The party who alleges any malpractice must prove his allegation by adducing trustworthy evidence on record. Otherwise, the same would fall apart. The DWs have proved that Haran Allah accepted the consideration money from the defendants and that he put his LTI on the said deed in his presence. Therefore, as stated by DW2, 3, and 4, the learned trial judge had said that their evidence could not be shaken, and their evidence shows that defendant number that consideration money has been passed on to Haran Chandra Allah. The defendants were not related to Haran Chandra Allah. They are complete strangers to the suit property. They have claimed that they have purchased the same from Haran Allah, and this suit has not found any unnatural thing in it. It has been proved by the defendant that they have purchased the suit property from Haran Chandra Allah from the consideration and the matter they would have purchased any property from anyone. This court has found merit in submission made by the learned advocate of the defendant that recording in the arrest record of right was correct. It was all his probable that the father of the defendants was alive when the same was published. there was no proof that he challenged the entries made therein during his lifetime. Exhibit 8 was the order number 3 dated 24 July 1997, which was passed in title suit 64 of 1997. The said order revealed the names of defendant number 2 and 3 was expunged on the prayer of the plaintiff and the defendant number 1 of the said suit. It was clear in the said order that Haran Chandra Ala was the plaintiff therein, and the plaintiff number 1 in present suit was the pro forma defendant number 2, and Jugal Chandra Ala, since deceased, was the pro forma defendant number 3. That the said suit ended on compromise. The Solenama degree in title suit 64 of 1997 revealed that the title of Haran Chandra Ala was declared in respect of 26 decimals of plot of land in plot number 382, 16 decimals in plot number 398, and 17 decimals of land in plot number 392. All the
We are not concerned with
we
this.
are not concerned at all. Then Milord kindly, Milord comes to Milord the last page. Milord, where Milord the court is discussing section 111 of the Evidence Act. Milord kindly see evidence 111, Milord. The judgment as referred by the learned advocate of the plaintiff, this court most humbly opines that no manner of application in the facts and of the circumstances in the present suit in the said judgment, the honorable court held following. Then, Milord, I'm skipping over that. In the present case, it has not been proved that Haran Chandra Ala was anyway dependent upon the defendants who are not related to him. In order to declare a particular deed void or on the ground of undue influence, the party alleging must prove before the court that person in whose name the said deed stood got the same executed by dominating the will of the transferee. The plaintiff, and as the court has found, could not at all prove that the defendants are in a position to dominate the will of Haran Chandra Ala. Therefore, the allegation remained unproved. Hence, the suit was dismissed. Milord, challenging that, Milord, appeal was preferred. Milord, appeal court, Milord, virtually gave the same findings. Only a few, Milord, paragraphs I will be showing to your lordship. Yes, kindly comes to me, Lord, the paragraph, page 19 of the judgment of the appeal court.
Yes.
Kindly see, my lord, the third paragraph in appeal, the appellant plaintiff have filed an application for amendment of plaint under Order 6, Rule 17 on dated 20th March 2012. They want to insert the facts elaborating their original case that they had already made before the trial court towards erroneous recording of RSROR. Therefore, considering the prayer for amendment of plaint, the absence of sensible discussion by the learned trial court in the impugned judgment over the erroneous recording in RSROR, the case apparently fits to be appears to be a fit for remand, but as a matter of fact, the same does not so. Why? Let us explain. Now, Milord, kindly, Milord, sees Milord the order dated 5th October 2018. Kindly sees Milord the order dated 5th, the order of Milord of admitting the appeal. Kindly see, Milord, the question number 3.
Even after recording the finding that it is a fit case for remand.
Exactly. Now, Milord, let me proceed, Milord. We have found the learned trial court as misplaced in accepting the evidence adduced by the plaintiff appellant. No valid reason is found to have assigned for accepting the correctness of recording in RSROR with respect to Khotiar number 67. The appellant plaintiff, in order to lubricate their case against erroneous recording in RSROR, want to amend their pleadings. Now, if we allow the plaintiff's appellant amend their pleadings and send the case for remand by allowing the parties to litigate further over this point, then also the efforts would be futile. Why? First of all, the state of West Bengal has not been made a party in the original suit, whose presence is necessary for a comprehensive adjudication over the claim over any claim of erroneous recording in ROR. Coming to the nature of the instant suit, it is only declaration and injunction, and even if the plaintiff appellant succeed in their case on erroneous recording in RSROR in establishing their half share in the suit property, the status of the defendant respondent would nothing but co-sharers in respect of the suit property. Therefore, owing to the nature of the suit being declaration and injunction, no decree can be passed against the co-sharer without praying for partition, being the only efficacious relief what a co-sharer can have against the other co-sharer. In other words, the purpose would not be served by keeping this lease alive pending between the parties. It is only because in absence of the relief of partition, thus the application for amendment of claim as filed by the plaintiff, appellant plaintiff does not hold any water owing to the nature of the relief claim in the original suit, and accordingly the same calls for no action by this court. Now come to the plot number 392. These plots have not been covered by Exhibit B. The defendants did not claim their right title and interest over these plots. The cause of action in the original suit was only with regard to the existence of the deed dated 31st August 1998. This being the position, noting what nothing was found in the entire material on record which would ask for any adjudication of the title of the plaintiff appellant over these plots. On the other hand, considering the validity of Exhibit B, this court has already found that the rest part of plot number 371 by 1245 and 444 belongs to the appellant plaintiff, but owing to the nature of the suit being declaration and injunction, no decree can be passed in absence of the suit for partition. This apart, plot number 374, item number 4 in the schedule of the plate includes only part of plot part of the plot being 9 decimal out of 13 decimal without any boundary. Over such indefinite portion of plot, no declaration and injunction can be granted. And Milord 374, Milord, without boundaries, Milord 374 was recorded as pond. Cannot be.
First of all, as regards these dark numbers, is the discussion required?
Milord, dark.
What has happened before at the time of revisional settlement? Are we concerned with those things?
Milord,
what happened at the time of divisional settlement?
Divisional settlement recorded in the name of Haram, there is no doubt.
Has been dealt with by the trial court.
Appellate court.
Appellate. First appellate court.
Earlier by the trial court.
Yes.
So not exhaustively, but by the first appellate court exhaustively. Was it required?
In my opinion,
Completely drifted that apart. That are not required.
Now let us come to the decision.
Yes. Decision with reasons.
Oh.
Decision, my lord, only the deed has been upheld, my lord. That is two things, my lord. If your lordship would
So
find
as regards to reasoning, as regards to the document,
page 12, page 12.
page 12.
Yes. It starts with Exhibit B by discharging their burden.
Exhibit B by discharging
Yes.
the burden.
Discharging their burden. Kindly see, my lord, the page 11, the validity and legality of Exhibit B, my lord. There it starts, my lord.
Validity and legality of
Clerk of this court takes the privilege to quote the following quoted passage, my lord. Then it was quoted. Exhibit B in the suit was registered as deed of sale. It was admitted into evidence without any objection. It is without any objection. It is Exhibit B. Does this Exhibit B carry any presumption as to its existence? To answer, this court wishes to be guided by the observation made in such and such, which was subsequently for such and such. Admittedly, the defendants, respondents had neither any fiduciary relationship with nor had any control over the daily life of Haran Chandra Ala, nor even the said deed in question was a deed of gift. Had this consideration has been answered in affirmative, the defendant respondent could not have initially saddled with the obligation to prove the legality and validity of Exhibit B. Since it was no, so let us see the plaintiff appellant when able to assail the Exhibit B by discharging the evidence. So as engrafted in section 101 of the Evidence Act. It was not disputed that Haran Chandra Ala died on 1st September 1998, that is on the day of execution of the on the following day of execution of the deed in question. According to the appellant plaintiff, he was completely bedridden since 28th August 1998. As he met with a cerebral attack on that day. No clinging evidence was there on the part of the plaintiff appellant which can prove that Haran Chandra Ala was unconscious at least on 31st August 1998. The only document, Exhibit 15, was produced in support of this fact by appellant plaintiff. The PW4 was examined to prove the document. PW4 claimed to be the compounder of one Dr. S.K. Banerjee. Curiously, being the compounder of Dr. S.K. Banerjee, PW4 had failed to disclose the name of the doctor. Therefore, the learned trial court has rightly discounted Exhibit 15. On the other hand, let us see what revealed in the cross-examination of witness examination.
Same view what has been taken by the trial
appellate court.
No, appellate court has taken the same view.
Then, my lord, kindly see, my lord, a few recordings.
Fiduciary relationship, no control over the daily life, and herein
identical record findings. Kindly see page, the next page. There it starts, my lord, film. Therefore, next page. Therefore, all the above facts came during cross-examination of the witness of the defendant's respondents. This apart, the DW2 in his examination in chief had specifically stated that he brought Motiur Rahman, the scribe of the deed in question, before Haran Chandra Ala, and as per the statement of Haran Chandra Ala, Mir Motiur Rahman drafted the deed in question in a white paper initially which was subsequently finalized, and he gave it to Haran Chandra Ala. He had also stated that Haran Chandra Ala was found unable to sign on the relevant day for which his LTI was taken and identified by him. He had further mouthed that the deed in question was executed in commission and commission and Haran Chandra Ala in presence of sub registrar took rupees 10,000 and put LTI on the deed in question. Curiously, none of these facts were either cross-examined or suggested in the form of denial during cross-examination of DW2. Lord, I'll show Lord the cross-examination of DW1. Lord, these facts do not put in DW2, DW1. Lord, confirm these facts. Kindly, I'll show it to. The DW3 in his examination in chief had stated that Haran Chandra Ala put his LTI on the deed in his presence, which was taken by DW2. He also stated that DW1 gave rupees 10,000 to Haran Chandra Ala in presence of all, including sub-registrar. He also stated that Haran Chandra Ala was fit on 31st August 1998. Again, Milord, the contradictions noted by the trial court, also Milord First Appellate Court. DW1 says he was fit, and Milord to cover up, Milord their Motiur Rahman, their deed writer, who was the DW2, he says, well, his hands were shaking, his hands were trembling, but he was he was able to understand what is going on. But he says affirmative, he was completely fit. He had expedited that since Haran Ala was incapable to sign, he put his LTI on the deed in presence of all. Herein also no cross-examination, no suggestion, even in the form of denial, and there was was there to the DW3 over his statement and as made in the examination in chief. Thus, what we have found, instead of any cross-examination over their statements ratifying the proper execution of the deed in question, the DW1, 2, and 3 had, in reply to some positive question, put them during their respective non-cross-examination, stated some facts which doubtlessly sanctioned the validity of the deed in question. This being the position, this court makes an addendum with the observation of the trial court, and accordingly it sanctions over the legality and validity towards the execution of the registration of the deed. This is and the next is whether he has right to transfer. That is perhaps not necessary. Next day, I'll be placing the deed in its entirety and the portions of the cross-examination.
Counsel representing the appellants commences his submission, but could not conclude the same due to paucity of time. Let the matter appear on 9th of January. For further hearing. What to be done? Not today.
Well, so for the 4 and 5 is concerned, well, I know, your lordship not been called it as it. Well, Chief, kindly take up this matter any date your lordship suits.
So, on 9th, that one will remain at the top.
We are not asking for 10:30. You lordship make it 2 p.m. at least.
Why not 10:30?
My lord, because my lord, subject to kind sanction, my lord, your lordship, kindly.
Yes, that matter will be at the top. I
Expect my last.
It could have been ended today itself.
My lord, so far 4 and 5 is concerned, your lordship, kindly make it, my lord, on 9th, but 2 p.m. fix, your lordship, so that we can try our luck.
হয়ে গেল, complete হয়ে গেল।
তো বেরিয়ে গেল।
জিনিসটা হচ্ছে 1 নম্বর item. 9 SA 100 of 2019 will be the item number 1. Thereafter, this one.
Our case
My lord,
may be, my lord, at 2 p.m.
No,
So,
no.
my lord, 4 and 5 next, your lordship.
Excellent.
Item number 3, that is SAT 458, will be in item number 2 on 9th of January.
Okay.
Item number 2.
I was beseeching your lordship, if possible, at 2 p.m. If possible.
No. Second item, thereafter, each and every matter will come accordingly.
My lord, so far, with due respect, lordship, I am not disturbing your lordship, my lord. My lord, so the item number 4 and 5
Each
is,
and every item will hold its position.
I know, I don't mind, but only I adding this point, my lord, if my lord diary permits, my lord, kindly make it 2 p.m. so that, my lord, after completion of serial number 1, serial number 2, my lord, we can, my lord, come up before lordship will get ready and dispose of matter. Matter pending since, my lord, kindly appreciate. If diary permits lordship and your lordship suits.
Let it be in the list as item number 3. Thereafter, we'll see. Item number 3, 4
9th,
on 9th.
so kind of lordship. Or your lordship can, any other days, my lord, at 2 p.m. so that we can try.
Why are you preferring at 2 p.m.? Because of the cold weather?
No, I'm not on that. Even if your lordship thinks of 5th, I will be.
It will take sufficient time of yours. After the completion of the first item, which will be at top, thereafter the item number 2, it will take sufficient time. You will get the opportunity.
Lordship.
But from this end, I have conveyed happy and prosperous new year to all of you.
Dear lordship. So kind of lordship.